In working with buyers, we're going to take just a few minutes now and look at our buyer agency agreement. So it's Form 201. Again, if you're never expected to memorize the form numbers. But if you have an idea of what the numbers mean, it makes the forms easier to find. There are a ton of forms out there, and if you're just randomly looking, the 100 series forms are working with sellers. The 200 series forms are working with buyers. I don't know what 300 are. 400 series forms are property management. 500 series are commercial. So having an idea of the number can help you locate it. If not, having an idea of the name, so you can start searching the name. But there's nothing like not being able to find a form and you're having to go through the entire forms library. So again, knowing the ideally or basic idea of where you can find some of your more commonly used forms. So the one we're going to look at now is 201, which is our exclusive buyer agency agreement. And we're going to see, it won't take us as long to get through this one as it did the listing agreement, because we're going to see a lot of similarities. But there are a few differences because we are working with a different party now. So there are some differences. So exclusive buyer agency agreement. Again, this form does come with guidelines to complete. So if you're not sure about what goes in a form or not sure about what something means, the guidelines is a great place to start. You guys know, you also have your manual, your real estate manual sitting in front of you. Your buyer agency agreement discussion starts in your book on 255. So it kind of goes through some of the provisions of the agency agreement. Of course, you also have your BIC and you have peers in your office. So another one of my super simple philosophies, when in doubt, find out. We have the tools and the resources to make sure that we're properly completing these forms for our buyers and sellers. So the buyer agency agreement is between the buyer and the firm, not the individual agent. This just goes on to explain, again, similar to the listing agreement, explaining to the buyer that the agent you've been working with is probably the one you're going to be communicating with. However, understand that the firm has the right to replace that buyer's agent, for example. So again, we're all with Julie's Real Estate Shop. Camille has a buyer's agency agreement. Camille goes looking for greener pastures, and she has the audacity to leave Julie's Real Estate Shop. Just kidding, you can go. Is Camille going to take her buyer with her? Should Camille expect to take her buyer with her? No, because it's not Camille's buyer, is it? It's my buyer. I'm just allowing her to work with it. Now, maybe I will allow her to take it. Maybe I won't. That could be up to the firm's policy. But if I don't, then the rest of you are in as buyer sub-agents. Once Camille got a buyer, the rest of all of us got a buyer. And so if I don't allow Camille to take it, then I'm going to say, all right, Taylor, you want a buyer? Of which course Taylor is going to say, yeah, because sometimes those things don't fall in your lap. So when they do, take advantage of that. Could I maybe ask Taylor to pay Camille a referral fee? All that stuff. Again, you guys, the answer to all those questions are, it depends. If Camille just picked this buyer up yesterday and she leaves my firm today, no, you're not getting a referral fee. You didn't do anything for it. Now, Camille's been working with this buyer for 4, 5, 6 months, and she has to leave him behind with Taylor, then yeah, maybe we will try to get a referral fee. But the bottom line is it just depends, and the firm's policy may play a part in that. Buyer's going to represent that as of the effective date, they are not a party to a buyer representation agreement with another firm. Buyer also represents that they've received a copy of the Working with Real Estate Agent disclosure and reviewed it with the firm. Again, that's past tense. So that's under the impression that it's already happened. We should not be doing this, presumably, well, for the most part, at the same time as we're doing our buyer agency agreement. Buyer further represents that they've disclosed to the firm information about any properties of the type described below, buyers visit an open house, or that buyer has been shown by any other real estate firm. So they've provided that information. So right off the bat, something that we see in the buyer's agency agreement that we don't see in the listing agreement is we have a place to identify the type of property that your buyer is interested in buying. So first off, we're going to identify if this is a residential property or commercial property or other. Is it industrial, agricultural, etc.? And then we're going to list the general location. General location tends to be where you are willing to go. So if you're going to limit yourself, let's just say you just want to do Forsyth County, then your general location is Forsyth County. If you're willing to go anywhere in the triad, you can put in the triad. If you're going to put in the state of North Carolina, you need to be prepared to go anywhere within the state of North Carolina, because you're telling your buyer, I will help you buy a home anywhere from Murphy to Banio. So just be prepared. I don't want you guys to limit yourselves too much, but I don't want you to create an expectation, an unrealistic expectation for the buyer. Does this make sense? So, if your buyer says, I need to be in Winston city limits, maybe you do Forsyth County just in case they find something just on the out layer of Winston, right? So this may come as a conversation with your buyer as well. The general location or the other might also be where we're going to put that verbiage, that specific property address. So remember before lunch, we talked about that hesitant buyer. We've been in an oral buyer agency agreement. I'm ready to present an offer on your behalf. All I need you to do is sign this. And the buyer says, yeah, I'm not sure if I want to sign that or not. All right. One of our options, possible solution, is to see if the buyer would be willing to enter into an agency agreement just for this address so I can present the offer on their behalf. And that's the case where we could actually put in here, or general location, either one, 123 Main Street, anywhere USA, or anywhere North Carolina, I should say, anywhere North Carolina. So the specific address. That only creates buyer agency or written buyer agency for this one property, so you can present that offer. That other, anything else about the type of property that the buyer's looking for? Is there anything specific? Do they need maybe land with a mobile home or something, for example? Just whatever it has, so we know we're all on the same page. Comments on that? The effect of the agreement: buyer intends to acquire real property, the type described in paragraph 1 above. By employing the firm, buyer agrees to conduct all negotiations for such property through the firm, refer the firm to all inquiries received in any form from other firms, prospective sources at any time during this agreement. One of our musts is we have a definite expiration date. We have a definite end date. So it tells us the term of this agreement begins on the effective date. The effective date is when everybody signs it, communication of acceptance, and it's going to terminate as follows. And then when we're working with buyers, we got possibility for 2 different terminations. First off, for the buyer who intends to purchase a single property. This is the first time home buyer that just wants to buy 123 Main Street. We're going to have this agreement go through 11:50 p.m. on this date. The other option is for the buyer who purchases more than one property. Technically, our listing or buyer agency agreement ends when we've done our job. So when the buyer hires me to help them buy a house, once they buy, I've done my job, and that ends buyer agency. What if? What if an investor calls you and says, I want to add 12 properties to my portfolio this year. Will you help me? Of course, you're going to say, yeah, but we also want to make sure that that buyer agency agreement continues once they close on the first house, the second house, the third house. Does that make sense? So if you're helping somebody with multiple properties, more than one properties, then we would want to use the second option here. Again, that relationship could go through December 31st at 11:59 p.m. or whatever the two of you agree. Then we talk about compensation of firm. I feel like talking about compensation and wrapping our brains around compensation as a discussion to the buyer. I feel like this is a problem topic. So let's make sure we're good here on a few things. First off, our agency agreements are employment contracts. And any employment contract has got to discuss our commission. And that does include our buyer's agency agreement. The traditional resale transaction, we all know my commission's coming from the seller. We all know that. Seller offers my agent commission and MLS. What if it's not a traditional transaction? What if it's not in MLS, for example? What if it's a for sale by owner? Or what if it is in MLS and what we're being offered isn't what my firm expects to collect? So please don't always just assume that your commission's coming from the seller. Because if the seller's not willing, can't, or won't pay you, there's only other one party to the transaction to pay us. And that's where we need to make sure that we have this conversation with our buyers so that they understand. So the first piece of our compensation, firm acknowledges receipt of a non-refundable retainer fee in the amount of X amount, which shall or shall not be credited toward any compensation due to the firm under this agreement. If your firm's policy allows, you may be able to collect money from the buyer up front, which is referred to as the retainer fee. Again, when you hire an attorney, what's the attorney going to collect? They're going to collect a retainer fee. They're going to collect money to do some work for you up front until the big payday comes at the end of that court case. So this would be very similar to that. We put wear and tear on our cars driving all over town showing properties, don't we? It takes time to find properties to show. And then we got to schedule those showings. We got to coordinate with people. There's stuff involved in working with buyers. And so some firms, some agents believe in collecting a retainer fee up front. Again, whether or not you can do this may come down to your firm's policy. I will tell you this. Commission rule says we cannot collect a retainer fee on an oral buyer agency agreement. So if you're going to start the practice, get with your BIC first. But if you're going to start the practice of collecting a retainer fee, all of your buyer's agency agreements are in writing. Okay. The second form of commission compensation is going to come for services hereunder. In other words, when I help you buy, in the amount of. So we're going to put a fee in, and we're told to insert dollar amount, percentage of purchase price, or other method for determining the firm's compensation that the buyer may purchase. And then we're told, do not put in 0. The number that goes here needs to be your firm's policy. Whatever your firm expects to collect when this buyer buys. If you put in 0 or NA, and your buyer all of a sudden inquires about a for sale by owner, and the for sale by owner says, I'm not going to pay you, and you have an agency agreement with your buyer that says they're not going to pay you, how much are you getting paid for that transaction? The amount you put in, big fat 0. Guys, this was a problem, so much so that they had to add this last sentence. This is probably a couple years ago. Don't you put 0. The amount you put in here is what your firm expects to collect. Where are we going to get it from? We haven't made it that far. All we know is this is what the firm expects to collect. Some firms may collect X amount for a resale buyer. It might be different for a new construction. It might be different for an unrepresented seller. So if your firm has different policies, collect an X amount for this type of transaction, you need to spell it all out here. X amount for resale, X amount for a FSBO, X amount for new construction. Make sure that we're clear, because we don't necessarily know what this buyer's buying. Even if the buyer thinks they're buying a resale, can't they switch gears somewhere along the lines and buy a new construction? So cover all possible bases up front. Protect your commission. Questions on that? Comments? I think we talked last week about this, mentioned the big lawsuit with NAR and Department of Justice. And a result of that lawsuit may change how we collect our commission. One theorist, one possibility says at the end of this lawsuit, we're going to start listing agents collect their commission from the sellers, and buyers agents collect their commission from the buyers. Depending on the result of this lawsuit, this could be a game changer, in which we have to learn how to roll with the punches. I think part of the problems with this lawsuit, part of it started it, we got a lot of sellers stepping up to the plate all of a sudden saying, it's not fair that I had to pay the buyer's agent's commission. I didn't hire the buyer's agent. Why did I have to pay their commission? So that's pretty much their stance. NAR is saying, why are you talking to us about this? We never dictated who paid how much commission. So NAR's sticking to their we don't price fix thing. I think another, not a direct result, but another thing that's happening that might be part of this lawsuit inadvertently, there's a lot of agents out there that advertise, if you hire me to be your buyer's agents, you don't have to pay a commission. You can hire me and my services are free. What are we telling? If we're advertising free, what do you get with free? What's that saying about us and our services if we're advertising that they're free? And guys, that's all fine and dandy until the buyer says, I want to buy a FSBO, and the FSBO is not willing to pay you. So now you got to come back and undo what you did in your advertising, right? Now you got to come back and say, well, I know you said you didn't have to pay me, but what about that listing that's in MLS that they're offering you a 0.5% commission? You told the buyer they didn't have to pay you. John's shaking his head no, saying he's not satisfied with a 0.5% commission. But John, you told that buyer you work for free. So pretty much how much are you going to get out of this transaction? You'll get your 0.5%, won't you? That money will be gone by the end of the day. So be very, very careful in what you tell the people. That's my point. Words matter. So do not advertise your services as free. We do work for money, and we do expect to collect X amount, whatever your firm's policy is when we work with a buyer. So the first thing is we determine how much we expect to get. Then our buyer's agency agreement says that the firm shall seek the fee from the listing firm or from the seller if there is no listing firm. And buyer agrees that firm shall be entitled to receive the same in consideration for the firm services. So the first thing I'm telling the buyer, this is how much I'm going to get when you buy a house. And the first thing I'm telling the buyer is that I'm always going to ask the seller or the seller's agents to pay me first. That is one promise I can make to my buyer. I will ask the seller or the seller's agent to pay me first. If the buyer purchases a property where compensation offered by the listing firm or the seller is less than the fee that we defined above, or where no compensation is offered by the listing firm or the seller, buyer and firm agree that the buyer will pay the difference between the fee and the compensation offered. So this is what we're telling our buyers. I'm always going to ask the seller first. And if they can't or won't, you're up. Somebody's got to pay me. There's only two parties in the transaction. So if the seller won't, or the seller's only offering 0.5%, the buyer will pay the difference. Firm will timely inform buyer if the compensation offer is less than expected. A buyer obtaining a VA loan may not be permitted to pay a brokerage fee or commission in connection with the services. Through use of a buyer agent is permitted. Firm may still seek compensation pursuant to this paragraph if the buyer is seeking a VA loan. If you start working with a VA buyer, make sure you are in communication with that VA lender, especially if that VA buyer is looking to go off of the MLS, if they're going after a for sale by owner. So that may be the one. And then you got a paragraph B1 below that we'll see in just a second. Questions or comments on that? I want to get y'all paid. We work hard, don't we? We deserve to be paid. The other piece of this we saw in our listing agreement, it's addressing additional compensation. I think we see this more with buyer's agents than we do with sellers. So we've already agreed up here that when this buyer buys, I expect to collect X amount of commission, whatever we fill in here. What if this buyer's going after new construction and the builder is offering a $500 bonus to the selling agent with any acceptable offers through the weekend? And you get your buyer under contract. Congratulations, you're now going to get, in addition to whatever we agree to, you're also going to get a $500 bonus. Commission rule says that my buyer, our client, I should say, has the right to know about additional compensation. When I'm going to make more than our agreed upon commission, we have got to disclose that to our principal. And so if we're going to get that additional compensation, we're reminded that we can use Form 770, which is going to address any additional compensation. We need to notify the buyer of this additional compensation before they present the offer. They need to have all the information in front of them when they are entering into this negotiations with the builder. Do not, this has happened, do not show up on settlement day and look at your buyers at the closing table and say, by the by, I'm about to make an extra $500 bonus. Just sign here saying you're okay with that. By settlement, you guys, it's too late. We need them to have all that information when they're making the decision before they present an offer. Let's think this through for a second. Seller typically pays the commission based off of the sales price, right? We're all good with that. Seller pays the commission off of the sales price. Who pays the sales price? The buyer. So technically, who pays our commission? The buyer. It's built into the sales price. So if you're going to make $500 more than promised, where's that probably coming to? It's not coming out of the seller's pocket, is it? It's going to be built into that sales price. So technically, who's paying that $500 bonus when they pay that sales price? You guys with me? Do you see why the buyers should care about this? Why we should notify the buyers? Because they're the ones spending that money buying that house. Our commission is rolled up all in that, bonuses, etc. I can promise you, if the builder's offering you a bonus, the sales price probably been jacked up a couple $100. Does this make sense? So we have a duty to notify our clients of additional compensation. Then again, same thing with the listing agreement. We talk about when our commission is earned. So if at any time during this agreement, buyer or anybody directly related to them enters into an agreement to purchase, option, exchange, we have earned our commission. Once we connect that buyer to that ready, willing, and able buyer, to that seller, to the property, the one they've been looking for, then technically we've earned our commission. Our buyer's agency agreement also has a protection period, as does the listing agreement. If within so many days of the expiration of the protection period, buyer enters into a contract to purchase another property that the buyer was introduced to during our agreement, the firm may be entitled to compensation. Of course, the caveat is if ours expires and the buyer enters into another agency agreement tomorrow, that firm will be due commission. That firm is the one that will be owed commission. Whomever has the current listing agreement. So as long as your buyer doesn't relist, or not relist, but re-enter into a buyer agency agreement, we may still be entitled to commission. So when we earn our commission is discussed in C, when the commission is due and payable. Always remember, when we earn our commission is different than when we actually get paid. I earn my commission when I connect a ready, willing, and able buyer. I typically don't get paid until it closes. Distributions of the proceeds from the sale of the property. This goes on to talk about buyer defaults. Compensation would have been due. The firm will be due and payable immediately in cash from the buyer. Again, whether or not the buyer defaults and they don't pay cash, now the question is, can we take them to court? That's not up to the individual agent. That's going to be up to the firm. I don't know many firms that take buyers and sellers to court over commission. News like that spreads like wildfire. We know how social media works, right? No buyer is going to want to hire a firm that's quick to sue. So I think we just don't see, I mean, I'm not saying it's not going to happen and it won't happen, but I think for the most part, if we don't close, we don't get paid. If buyer purchases on improved property, so land, agent may assist buyer in identifying a contractor to make improvements. Buyer acknowledges and understands that in such a case, a contract may offer to compensate the agent. Agent shall disclose to buyer the existence of an offer of compensation before buyer enters into a contract with the contractor. And buyer hereby consents to receipt of agent of any such compensation. I think this is good information, but it also helps serve as a reminder to us. Make sure you're getting with your BIC to negotiate your compensation. If the buyer buyers land and the transaction closes, this agency agreement is over. So then the builder goes on and builds and then sells to the buyer. You would need another agency agreement, right? Because we've already satisfied this agency agreement when they bought the land. So to get you paid when the house is built and that closes, if you're still going to be involved as a buyer's agent in the construction process from dirt to roof, if you're still going to be involved in that process, get with your BIC to make sure that your commission is spelled out properly in here. So we not only get you paid when the land closes, but also get you paid when the building closes, when the property closes. So many agents have been burnt. And so I think that's a big reason why this paragraph was added. Because if you're going to sell the land and then move on and never see these buyers again, then you don't deserve a commission when the property is built. But if you're going to be involved in that process, just get with your BIC to make sure your commission is covered. Questions on that? So we're good with that. Again, I'm just trying to get y'all paid. Other potential buyers. Buyer understands that other prospective purchasers represented by the firm may seek property, submit offers, and contract to purchase property through the firm, including the same or similar property as buyer seeks to purchase. Buyer acknowledges and understands and consents to such representation of other prospective purchasers by firm through its agents. Exclusivity in our agency agreements is a one-way street. The buyer is only agreeing to date one firm. The firm is dating multiple buyers. Think about it. If we could only work with one buyer at a time, it'd be really hard for any of us to make money. Yes. So the firm can date multiple buyers, which means, especially in this crazy market we're coming out of, the firm may have several buyers interested in the same property. Guess what? You, the individual agent, may have several buyers interested in the same property. So make sure you document everything. Make sure you proceed with caution. The CMA you do for one buyer should be similar to the CMA you're doing for your other buyer. The same information you're providing, the same information you're giving, you should be doing the same for both. When working with buyers, I think a big part of it is helping the buyer identify their risk tolerance. What are you willing to risk? What are you willing to give up? I mean, let's face it, buying a house is a big risk. Just in its nature of itself is a big risk. So helping the buyers identify their risk tolerance. You know, some people, they're just more tolerant to risk than others. You know, some people you could say, let's see, we're taking our test on Sunday afternoon. So, all right, guys, who's with me? Monday morning, I vote we hop in a plane and go to Vegas. Let's do it. Who's with me? John's going to come. Anybody else want to go to Vegas on Monday? John is probably a bigger risk taker than some others, right? Tatiana, after she thought about it for a second. So she's a risk taker once she considers the risks. You know, she's got to think about it. Then you're going to have other buyers that if you say something like, hey, after class today, swing by Sheetz and pick you up a scratch off ticket. And you're going to have other buyers go, no, I'm not going to waste that $5. It's too risky. And that's what I mean by helping them identify their risks. Some people are willing to take more risks, and that's how we can help two buyers present offers on the same property. I'm not telling anybody what to do, but I'm saying based on this information, what are you comfortable doing? How much due diligence are you willing to give up? How much earnest money are you willing to put down? So we can assist two buyers in making offers on the same property, but we just need to make sure that we're treading carefully, treading lightly. What you do for one, you do for all. So again, all you got to do is one CMA. You don't even have to do two, and let them make those decisions. We certainly don't want to favor one buyer over the other. Questions on that? Have you guys encountered that yet? Especially as provisional brokers? No? Closest I ever got, I showed the same buyers, the same house, but by the time I showed the second buyers, my first buyers had already ruled it out. So when I went back the second time with the second buyers, and they pretty much had the same opinion as well. So the buyers are speaking about that property. Now we're just waiting on the listing agent. But that's the closest I ever got to it. And that was probably a couple weeks apart. It wasn't even like it was back to back. It was a mad sense of deja vu. I feel like I'd already been with those buyers in this house before. I guess because I had. Again, our agency agreements are bilateral contracts, which means both sides have duties and obligations to each other. So first off, the firm's duties to the buyer. The general duties of the firm: performing the terms under this agreement, seeking a property at a price and terms acceptable to the buyer, presenting all offers on behalf of the buyer, and disclosing to the buyer all material facts relating to the property, and then accounting for the buyer in a timely manner, money in the property received in which the buyer may have an interest. The firm also has this duty of confidentiality. We're going to maintain confidentiality of all personal and financial information, other matters identified as confidential by the buyer. We're going to exercise a reasonable standard of care. We're going to comply with all applicable laws and regulations. We have a duty to treat all sellers honestly and not knowingly give them false information. Representation of others: firm may show the same property to other buyers, represent other buyers, represent sellers. And then submission of information to the listing service. If your buyer buys a property that's not in MLS, so for example, if your buyer buys a for sale by owner, once this is all closed, some MLSs may require you to put it in, it'll go in for comp purposes only. So it'll never be active. You're going to put it in as closed, and you're going to indicate in the remarks that it's for comp purposes only. That way you and I can use it for the CMA, and the appraiser can use it for their sales comparison approach. And all you got to do is put in the bare minimum. I mean, it's not like you have to, do a full-blown listing, but that helps others use this sale for their information. Disclosure of buyer's name, mailing address. Some buyers don't want their name issued. Some buyers don't want their contact information. Firm has buyer's permission to disclose the buyer's name unless otherwise stated below. So we'll see that in a second. If you're working with a buyer that also happens to be a local celebrity, maybe they're the guy that does the 6 o'clock news. I know here in the Triad, we all know Van, don't we? We know Van Dent. We all know Van, like he's our buddy. So if you're going to help Van buy a house and the seller looks at that name, could the seller recognize that name and think to themselves, he's the chief meteorologist for Fox 8 News. I bet you he makes some good money. I'm going to counter hire because I know he can afford it. Sometimes by releasing your buyer's identity, we may be giving away what they think is their negotiating power. So if you have a little local celebrity, I used the example of Cam Newton, but Cam's not really a little local celebrity anymore. So I need to know. They don't really have a good quarterback anymore, do they? So Van Denton it is. We're going to stick with Van. But you guys are with me. If it's a name that they can recognize. I mean, we're in NASCAR country here. So we got NASCAR drivers all over the place. They got to buy houses too. So if you're working with somebody that could be recognized, somebody that could be, you may well see in paragraph 13, how we may want to keep their name confidential for a while. Also in accordance with this North Carolina general statute, if a dispute regarding the return or forfeiture of earnest money arises, then buyer agrees that if the parties don't agree to release the earnest money, then the escrow agent is going to deposit that money into the clerk of courts and let the two go downtown and hash it out. So if we terminate and the earnest money's in dispute, the parties have to agree to release the earnest money. The escrow agent can't. All they can do is turn it over to the clerk of court's office. Here's our non-discrimination clause. We saw this in the listing agreement. So the firm shall conduct all brokerage activities in regard to this agreement without respect to the race, color, religion, sex, national origin, handicap, or familial status of any party or prospective party. Further, we have an ethical duty to conduct such activities without respect to sexual orientation or gender identity of any parties or prospective parties. Red warning's been added to address buyer letters to sellers. I tend to call these heartstring letters. Again, we saw this in our listing agreement. The concern with these heartstring letters is that we could be bumping into violations of fair housing. So like we talked about with the listing agreement, if your buyer submits a letter and says, I think you should select my offer because my family and I can envision ourselves spending Christmas Eve in this gorgeous living room. In one sentence, you bumped on fair housing twice, didn't you? Familial status and religion. It's really, really easy to do. So when you talk about the people, anytime, even if the people are talking about the people, you still need to be careful. These love letters are not illegal yet, but they do come with caution. I don't think we're seeing these love letters as much anymore since we're coming out of this crazy seller's market. But I know there was a period a year or so ago that like every offer had these things. So that's when we started seeing these warnings pop up in our agency agreements. I mean, they had a class on it from NCAR. And bottom line, you guys, we just need to make sure that we never engage in anything that could be seen as discriminatory in fair housing. Have you guys seen these letters yet? Have you had buyers ask you, Camille's not dealt with this? John Hat and Tatiana. And I have a feeling they're going away, but this is what happens. Somebody knows somebody that knew somebody that got a house because they wrote a letter. So now what does this buyer think? They're going to get a house because they wrote a letter. Again, it just bumps into some fair housing. I mean, I tend to think that the sellers care more about the dollar signs than the people. That's just my opinion. I would if I was selling my house. If you want to impress me and wow me and make me choose your offer, show me in terms of money. I think that's the best way to get your buyer's offer accepted, not try to play on the seller's emotions. Sellers should only see one color, shouldn't they? That color is green. And that's it. So as a buyer's agent, if your buyer wants to submit a letter, we need to have this fair housing conversation with them. Some agents, because I still can't stop the buyer from doing it. Again, this isn't illegal. But what some agents may do is say, hand me this letter in a sealed envelope, and I'll deliver it to the listing agent. And then that way you never see it. Just a couple things to take into consideration. Thoughts on that? There it is. So we saw the firm's duties to the buyer. So here's the buyer's duties to the firm. Buyer agrees to cooperate with firm in the acquisition of real property of the type of property described above, but not limited to. Buyer agrees to work exclusively with the firm during this term, meaning they can't talk to any other firm. I mean, can they? Yes. But they're in a legally binding contract that says they're only talking to me about the properties that they want to purchase. Buyer agrees to immediately refer to the firm information about any properties buyer may have interest in examining. Comply with reasonable requests of the firm to supply financial information, obtaining a pre-qualification letter, for example. Buyer agrees to be available for reasonable periods of time to examine properties. Similar to the sellers, it's going to be hard for me to sell you a house if you never, ever, ever have availability to go see a house. So if you hire me to help you sell a house, then you need to have some time to go see a house. Examining properties only by appointment made by the firm and accompanied by an agent of a firm. I think this one needs to be in bold in caps. This is worth a conversation for our buyers. Even when they're under contract, they still can't go to that home without us. They need to contact us to schedule an appointment through showing time. When they want to go look at paint samples, that's fine. Let's find a time to go. You want to go see if your couch will fit in the living room? Grab your measuring tape. We'll schedule the appointment to go. Sometimes I think buyers think they're under contract, so they have the right to enter the property anytime they want. There have been cases, y'all. The sellers are sitting there one evening after dinner watching TV. They're under contract, and here come the buyers peeking in the windows. I think some people would call that trespassing. I don't know about your house, but at mine, that's a pretty good way to get yourself popped. So just make sure that your buyers understand it's not their home yet. And if they want to go to the property, they need you to schedule an appointment and they need you to be with them. Buyer has a duty to conduct all negotiations and communications through the firm. Buyer has a duty to conduct all due diligence on the property in consultation with the firm. And then the buyer has a duty to pay for all products and services required to examine the property. So the buyer's responsible for paying their surveys, their inspections, their tests, etc. So the buyer's duties to the firm. Other professional advice. We see this paragraph in the listing agreement. but I think it's more relevant in the buyer's agency agreement. Buyers are more apt to ask, who should I use for a home inspector? Who should I use for a surveyor? Who should I use for a closing attorney? Who do you recommend to do this, this, and this? And this paragraph is covering that. What this paragraph is saying is that I can make suggestions on other professional advice. I cannot make you use anybody, and I cannot guarantee their work. If I'm making a suggestion, it's because I've had a good experience with them in the past. With that being said, doesn't everybody have a bad day every once in a while? I mean, I have a bad day sometimes, you know? So you may have had stellar experience with your home inspector for the last 3 years. You suggest this buyer uses his home inspector. The home inspector is having a bad day. Is that your fault? No, and it's probably not the home inspector's fault. Again, you've had a great experience with them for the last 3 years. Just make sure that buyer understands your recommended services. You're not guaranteeing the work. And again, if you're recommending services, don't go or send your buyers to Google. Use a preferred vendor list, either from your firm, or as you guys are getting started, you're getting out there, my active people, you're starting to meet these vendors, right? You go to a board of realtor event, there's probably a home inspector or homeowner's insurance agent there, somebody there willing to meet you and hand you their business cards. So getting out and networking, meeting people, that's a great way just to start building your own vendor list. Anybody have people dropping stuff off at the office? We got some donuts last week, you know, that kind of thing. So they come in, that's another way to meet them. They come in with food, that's the way to our hearts. They come in with food. Maybe we got to listen to their spiel, but that's other ways that we can meet these preferred vendors. Buyer acknowledges receipt of a sample offer to purchase and contract. Buyer acknowledges receipt of a sample professional services disclosure and election. If you're not giving the sample, then don't check these boxes. This is another fantastic form. I don't know if my active people are familiar with this one yet. We're going to look at this one briefly. I'm actually going to go off syllabus because this is such a good form, and this is a form for us, another way to protect us. So if you're not familiar with this form yet, we're going to go off syllabus in just a second and look at it. Do my active people use it? Professional service? Yeah, this is our form, you guys. So yeah, we'll talk about that and the importance. Discussing the home warranty with the buyer. We're going to let the buyer here know that maybe the seller will provide the home warranty. If the seller's not willing to provide the home warranty, maybe we'll ask the seller if they want to provide the home warranty. If the seller's not going to provide it, the buyer has the right to purchase their own home warranty if they wish. A lot of firms have a home warranty company that we have a relationship and we talk to. We can still encourage our buyer to shop around. There are so many companies out there that, for the most part, offer the same product. So whatever home warranty company is currently talking to your firm, that very well may be a great place to start and helping you make recommendations. You talk about feeding real estate firms. At the end of the pandemic, about the time that we were allowed to start being together again, is when we started seeing food come back in the office, right? So that was very exciting. And we had a home warranty company offer to bring us lunch one day. They said, we'll go to Taco Mama and bring y'all some lunch. Of course, we said, yeah, well, when a home warranty or anybody brings you lunch, you got to listen to their spiel, right? That's just the courteous thing to do. So home warranty brought us Taco Mama, and we were listening to their talk, eating our tacos. It was a good day. And while we were sitting in there, y'all ready for this? A representative from another home warranty company came in to drop off a box of pastries. Oh, it was awkward. Oh, it was so awkward. Now, they were just dropping off pastries and some business cards and leaving. So it's not like they hung around any longer than what they had to. It was really awkward. But we now walked away with 2 different home warranty companies that we could communicate with, that we had business cards for that day. I'd take a taco over a pastry any day of the week. So I think we I think we got the best bet there. But yeah, they're coming back in the office full force. You're going to start getting lunch and donuts and all that other good stuff again. Great way to meet vendors. Confidentiality of offers. Remember, commission rule says I cannot disclose the terms of an offer without the offeror's permission. The offeror is the person making the offer. Is anybody in their right mind going to give you permission to disclose the terms of their offer? You're in a multiple offer situation. No, they're not going to give you permission. No. But commission rule says we can disclose those terms of the offer. We just need the offeror's permission. So back to our scenario. You're one agent assisting two buyers, helping them write offers on the same property. Can I pit my buyers together? I know this is what the Joneses are offering. Can you beat this? The Smiths came up to this. You think you can top that? I cannot pit them together. So that's another way to protect our buyers if we, again, are the same agent helping two buyers with the same property. I'm giving them information, but I'm not sharing their information. What if you're the listing agent and you're listing a home that's fallen in this crazy multiple offer world, and you got 30, 40 offers in your hand? Another agent will call you. There's no rule that says that they can't ask. Another agent will call you and say, my guys are writing an offer. We'll present it to you by dinner tonight. What's the highest price offer you have in your hand right now? Can the listing agent answer that question? Not unless they have permission of that person making that highest price offer. Does this make sense? You got to prepare for the fact that they will call you and ask you. A lot of agents got themselves in trouble. There's no rule that says that they can't ask. The rule dictates how we respond. So we're not disclosing the terms. Let's see, additional provisions, anything you and the buyer agree to that hasn't been covered. We kind of got a space here to fill in whatever newly agreed upon terms. Here's dual agency as is explained to the buyer. So we saw dual agency explained to the seller in the listing agreement. And now we're explaining what dual agency means to the buyer. So disclosure of information, even though we're in dual agency, I'm telling the buyer that I'm not going to disclose certain information to their price, term, or motive, or any information that they consider confidential, unless commission rule or license law requires me to do so anyway. So I think that does help assure buyers and sellers a little bit dual agency that I still don't have a golden ticket to blab your confidential information. This goes over the firm's role as a dual agent, letting the buyer know that my advocacy goes away. I can't offer advice if we agree to dual agency. This is the buyer's role of dual agency, how they can help get through this. We're going to explain designated to them. And then same thing as the listing agreement. We got to get the buyer to consent. Either they're going to initial and agree to dual agency, or they want exclusive representation at all times, and they do not agree to dual agency. They got to initial one or the other. If they agree to dual, if we have a yes here, we need to know the buyer does or does not authorize the same agent to be a dual agent. So maybe the buyer says, I'm okay with dual agency, but I don't want you on both sides. So that means we'd have one agent in the firm working with the seller, and then you would be working with the buyer. Also, if they agree to dual and your firm allows it, your firm has a policy for it, then we can have the conversation to discuss designated to see if that's something we can get them to agree to as well. We got a whole section for dual and designated, so that'll be a good chance for us to recap and catch that information. The other thing about dual agency is discussing a dual agency compensation. Remember, dual agency is in-house, which means the firm is representing both buyer and seller. And some firms have a different compensation plan for an in-house transaction. So if your compensation plan switches up when we're in dual agency, we need to notify the seller. And that's that conversation we're going to have here under the dual agency compensation. Once again, we're instructed yeah, it doesn't tell us here not to hit 0, but it does reference us back to paragraph 4 where we instructed not to plug in 0. So just make sure you put a number in here. That's the only way I can guarantee to protect your commission. Because if you don't properly fill this in, you may not be entitled to your commission. So get with your firm, make sure their policies. Termination, breach, mediation, attorney's fees. Again, any good legally binding contracts and answer the question, what happens if either party breaches? So this covers that boilerplate stuff. We're going to agree to do mediation as opposed to this lengthy court battle if need be. Surveillance, we got to remind the buyers that while the sellers can have video, they should not have audio. Our listing agreement is a warning to the sellers. Video, yes. Audio, no. With that being said, I have a conversation with my buyers and I let them know that sellers shouldn't have audio. Careful what you say in the house. Some agents don't want their buyers walking in the house and nitpicking and calling something tacky or ugly. I don't really care about that. What I don't want is my buyer walking in the front door and saying something stupid like, I will do anything for this house. That just hurt their negotiation powers a little bit, didn't it? Because the seller, now they're seeing all sorts of green, aren't they? So that's what I caution my buyers about. And guys, remember Ring doorbells. Did I tell you guys last week, and I'm teaching the same class during the week too? So I'm like Pete and repeat here all of a sudden. So my guys, this past week, this came up when we were looking at our listing agreement. And one of my guys said, what about the Ring doorbell? Can you even turn those audio off? Can you even turn that off? And I'm not sure, we don't have a Ring doorbell. But you may not, you may have to go into your app and you may have a setting in there that you can turn audio off, but I doubt a lot of people would think about that. And I think he brings up a good point. Technology tends to move faster than the law. And while technology is rapidly taken off, the law takes time to catch up. So I feel like the technology of like the Ring doorbell, for example, has gotten moved on faster than the law. There may be a change, there may be an update in the law, I have no idea. But what I know right now is that the law says is that video's okay, audio's not. So the seller needs to take whatever couple extra steps those are to not have the audio. You know, again, if they want to turn their Ring doorbell off for a showing or whatever, or their audio off for a showing. But still, with all that being said, I have a conversation with my buyers about what being careful about what you say is to not harm your negotiating power inside and outside of the home, because we may not know what cameras they have out there that are picking up. Photographs and videos, unless we've been notified otherwise, the buyer can go through the home and take pictures. They can go through the home and take video. Buyer's agents, we need to watch that and make sure that the pictures and the videos that they're taking are of the space, that they're not zooming in on the stuff. Sometimes buyers are encouraged to take pictures and take notes. There was a market, buyer's markets, 10 years ago. You could spend all day Saturday showing your buyers 13 properties. You're going to meet at the office at 9 and we're going to be together all day. I got a lunch break planned for us. I got potty breaks scheduled in between. We're going to spend all day looking at 13 properties. We're getting back to that. I'm telling you right now, if you spend the day looking at 13 properties, after a while, all 13 of those properties are going to start running together. And better yet, your buyer's going to start piecemealing houses. Well, I like the kitchen in this one and the fireplace in that one. And now they're like creating a house from the 13 that they saw. So encouraging them to take notes and take pictures will help them keep those separated. And if pictures help, by all means. I have like little legal notepads that I carry around in my car. So if they don't have anything to write for them, I can say, you know, here you go, here's a pen, take notes. Again, if pictures and videos help, that's fine. We just need to make sure that they're not taking pictures of the stuff. Have you guys had a situation yet where you're supposed to show a property to a couple and maybe at the last minute, one of the spouses had to work late and they couldn't get to the showing, so the other spouse went on? They may be taking pictures and videos to show their significant other when they get off work. So if they can't be together, again, pictures and video help them have these conversations when they can't be. Just make sure we know what it is that they're showing. So talking about things that are in plain view, it's impermissible to take pictures or video of anything not in plain view. So in other words, we're not opening desk drawers or dresser drawers to take pictures of what's in the drawers. The other thing that the buyer acknowledges and understands is control of the information of the property on the internet once it closes. All we can do in this case would be the listing agent is go in MLS and close it. How all of those other websites receive it and what they do with it, I have zero control over. Every once in a while, a buyer will call and say, you know, we closed 3 months ago, but it's still showing active on this website. I don't know why they didn't pick it up. I have no control over this. The other thing too is once it closes, sometimes the pictures are still available. So again, making sure they know that their new home isn't just going to disappear from the internet once they close. Comments on any of that? Here's our wire fraud warning to the buyer, similar to the seller. Only now with wire fraud warning. These are the buyers wiring their closing funds to the closing attorney. So again, we're going to have the same conversation. Don't rely on wire transfer instructions that you get in an email. Never, ever, ever rely on wire transfer instructions that you get in an email. If your buyer wants to send their proceeds to the attorney via wire transfer, have them call the attorney and get that wire transfer instructions. That's on a number that either you provide them or they Google. Don't have them call on a number they receive in an email, because now you have them calling the hackers, and the hackers will be more than happy to give them their wire transfer instructions. So have that conversation to keep everybody safe. I got two places, for the buyers to sign. Print your name and signature, contact information. If it's an entity buyer, corporation or LLC, one buyer is entitled to sign on behalf of the corporation. And then you have the firm, license number, contact information, signed by the individual agent with their license number, another must, and then their contact information. Buyer's agency agreement, still only 7 pages. Questions on our buyer agency agreement? The other one we're going to look at, just real brief, Is this non-exclusive agency agreement? It is an agency agreement. We're just not demanding exclusivity. So again, this might be an option for that hesitant buyer. Check with your firm. Not all firms like this form because it's not demanding exclusivity. So your firm may have a policy whether or not we're going to use this firm or not. But if it does, you may want to look over this and consider using this for that hesitant buyer that's willing to enter into an exclusive agency agreement. Basically, what this form is saying with compensation is that I'm only going to get paid if I'm the procuring cause of you buying this house. If I'm my actions and my duties that led you to purchasing this home, that's the only way I'm entitled to compensation. Since we're not demanding exclusivity, this buyer may be working with other firms. So now we're back to that rat race, aren't we? The first one to find the buyer of the home wins. This is just taking that oral agency agreement and putting it in writing. Everything else here is pretty much the same. Just addressing this non-exclusive piece. My firm doesn't use this. Either you're with us or you're not. That's the way we are. Take me or leave me. We will work with an oral buyer agency, but my firm also has a policy that says the sooner you can get that thing in writing, the better. Pretty much it's about building trust, isn't it? Once they think they can trust you, that's when we say, great, sign here, date here, and initial here, here, and here. Thank you very much. Comments on this non-exclusive buyer agency? Let's take a break. We got 10:22, so we'll come back at 10:32. Work more with buyers. Okay, welcome back. So continuing on working with buyers, as a buyer's agent specifically, there's several duties, I guess we can go over, talk about things specific about working with the buyers. I think one of the big parts about working with buyers is educating on the prospect or the process, especially if this is a first-time home buyer. They may not know where to begin. They may know nothing more than contact an agent. Like we said earlier, if it's been 10, 15 years since they bought a house, I'm telling you right now, when they bought a house 15 years ago, it was different. So they might as well be first-time home buyers. So educating the buyer about the prospect, having conversations with them, particularly about what to expect in this market. Those of you working with buyers in this market or coming out of a strong seller's market, it's important that we understand, these buyers understand what kind of market they're trying to compete in, because it is a competitive market. I mean, it's like a cutthroat competitive market for these buyers. So help them prepare them for that process, what it is they can expect. I think one thing buyers, again, especially in this market, another thing to prepare buyers for is letting them know sellers aren't required to do repairs. Buyers generally don't like to hear that, do they? Because buyers want to buy the perfect home without anything wrong with it. But that's not realistic. So preparing them for that, let them know, hey, we'll ask them to do repairs, but making sure they understand that piece of the process, that they under no obligation to do so. Also, when working with buyers, we're going to help them determine their specific housing needs. When I'm working with buyers for the first time, I go old school, and I actually encourage them to take a piece of paper and draw a line down the middle. And on one side of the paper, spell out your wants, and on another side of the paper, spell out your needs. As a buyer's agent, no matter how they express their wants and needs to you, we need to be prepared for those wants and needs to change as they get out and start looking at property. Have you guys had buyers yet that they end up buying the exact home they told you on day one that they didn't want? Things change. Yeah, I had buyer, one of the first things she said to me was, I don't want a front loading garage. Front loading garage means the garage door is on the front of the house. She said, I want a side loading or a back loading garage. She said, I think that's the tackiest thing in the whole wide world to have a garage door in the front of the house. I said, cool. Remember what we said, if it's important to my buyers and it's important to me. So I got it. This was important to her. So we're looking at property, doing our thing. One day she sends me a property for sale, and guess what this house has? Front loading garage. I said, are you sure? Because on day one you told me no. And she said, no, I like this one. I said, y'all want to know what she ended up buying? A house with a front loading garage. So just be prepared for them to change, be prepared for them to pivot. Another thing I've learned in working with buyers, you got one spouse describing one home, you got the other spouse describing a different home. And I'm standing here going, how the heck am I going to get these two people under the same roof? Because they are talking about two different homes, two different things. So again, having them go through and identify those wants and needs, maybe can get everybody on the same page, or maybe we just sell one to one spouse and the other one to the other, and we get 2 commissions out of it. There we go. That's what we're going to do. But just helping them, see. And again, I took a class once, and I don't remember now what it was on, but I remember them saying, don't ask buyers MLS fields. Don't ask buyers questions like how many bedrooms do you want and how much square foot. Ask buyers questions like, what do you want to do with this space? What do you want to do with this home? Because they may look at you and say, let's see, if you have 2 married people and there's 2 kids, we're looking at 3 bedrooms. Yes, we got the primary, and then we have a room for each of the kid. So we're looking at 3 bedrooms, and they may say we need a 4-bedroom house. Well, they're not happy with anything 4-bedroom on the market. So maybe you start pivoting a little bit. All right, I'm doing the math. I see 3 bedrooms. What do we need the 4th bedroom for? And they may say, well, you know, since COVID, my husband works from home, so we need a dedicated office space just from, okay, this may change things a bit. Maybe we don't need a 4-bedroom. Maybe we need a 3-bedroom with an office, or a 3-bedroom with a bonus room, right? So by discussing their needs, discussing their wants, we may be able to help them fill in those MLS blanks. Another big thing in working with the buyer is helping the buyer get qualified. So the first thing we're going to want to do is make sure that we, once we ask them if they're working with an agent, and we do our working with real estate agent disclosure, and we determine in what capacity we're going to proceed, the third question that falls out of our mouth is, have you talked to a lender? We, as agents in whole, have got to stop showing property to buyers before they've talked to a lender. I don't understand this. I don't understand this. Why are you wasting your time? Why are you wasting their time? Have them talk to a lender. It's still no guarantee, but at least we know somebody out there thinks that they can afford a home in this price point. Require it, you guys. Require that they talk to the lender. And I think this is fairly new in the big picture of buying a house history. It used to be once upon a time ago, you found the house and then you talked to the lender. Today, we know things are different. Today, we know you talk to the lender first and then you find the house. So if you get an old school person that bought a house 20 years ago, they're not going to understand why you want them to talk to the lender first. To get this buyer qualified, ideally, we want to get them to the lender, but we're going to have a conversation. We're going to learn how we can quickly qualify a buyer ourselves in the event that the lender's not available. Again, I don't think we're having these kind of problems anymore, but it used to be that lenders work Monday through Friday, 9 to 5. Today, a lot of our lenders work when we work. We have a couple preferred lenders, and that's their exact quote. I work when you work. So if you're out in the evening, if you're out on Sunday, I work when you work. But you may still come across a lender, maybe the bank itself, that isn't going to be open in the evenings and the weekends. And if you meet a buyer, you want to run a quick qualification on them to make sure that you can show them properties before you ever talk to the lender on Monday morning. So having this understanding of that. So let's skip around in the book just a little bit again. And let's go to chapter 13. And in chapter 13, we're going to start picking up, this is our financing chapter. We're going to talk a little bit about the loan to value ratio, page 432. Tatiana, we are under maybe the loan application. Or maybe your big category is evaluation of borrower's qualification for a loan, residential real estate lending practices, somewhere under there. So on page 432, talking a little bit about the loan as it applies, pre-qualifying for the buyer. One thing that the lender is always going to consider is the loan to value ratio. The loan to value ratio, this is through the lender's eyes. And the loan to value ratio answers the question of the value of the property, what percentage do you want for the loan amount? The lender cares about the value. They will originate the loan on the value. So the lender defines the value as the appraised amount or the purchase price, whichever is less. So the loan will be issued on the purchase price or the appraised value, whichever is less. Let's talk about what's been happening in the last few years. Let's say we have a purchase price of, I don't know, y'all want to buy a big house? Let's buy a big house. We got a purchase price of $875,000. Go us. All right, so we're legally bound to the seller to buy their home for $875,000. That's our purchase price. We go under contract, or we are under contract. We have the appraisal done, and the appraisal comes in at, it's not too far. Maybe it's 868,000. So we're legally, contractually obligated to pay the seller 875,000. The appraisal comes back at 868. Which one is the lender going to base the loan off of? The lender's going to base the loan off of the 868 because that's the appraised amount. But we just said the buyer was contractually obligated to pay the seller $875,000. So I got a gap here of what, $7,000? We got to figure out how we're going to make up that difference now. So there's a couple different options we have. Buyer's agents, assuming we don't have an appraisal gap contingency or appraisal gap addendum built in. Buyer's agents, to protect my buyer, you know the first call I'm going to make? I'm going to call the seller. I'm going to ask him to renegotiate the purchase price from 875 to 868. Does the seller have to engage in renegotiations? Do they have to agree to lower the purchase price? No. But as a buyer's agent, wouldn't it be in my buyer's best interest if I pick up the phone and call and ask? Absolutely. So we're going to call the listing agent first. Hey, it appraised for 868. Is your seller willing to renegotiate the purchase price? Seller may say yes. Seller may say no. Seller may say, I'm not willing to drop it to 7,000, but maybe I'll drop it 3,500, right? So maybe we can get him to come down some or all of the difference. If they come down to 3,500, if they come down anything, but not quite to the 868, then the buyer's going to have to make up the difference. So it says the seller agrees to lower the price to 872. They said, this is low, I'm willing to go. Well, now the buyer's got to come up with $4,000, right? If the seller doesn't agree to lower the price, now the buyer's got to come up with $7,000. So now the question is, what if? What if the buyer doesn't have $7,000 laying around? What if they don't have that kind of cash? The number one question I get is, can they get a loan? And the answer to that question is, it's going to be tough because they're already trying to get a loan based off of $868,000 home. So to get another loan for $7,000 at the time they're trying to get a loan to buy a house, maybe challenges. The lender may not allow that. They may have a problem with that because remember, in default, the lender wants to make sure they get paid. So can the buyer get another loan? It's worth talking to the lender, but I wouldn't bank on that. By the way, when we talk about getting another loan to purchase to make up the difference, that does include a loan from a private source. And an example of a loan from a private source would be the bank of mom and dad. So they can't get a loan, not so much from Wells Fargo, Bank of America, but they may not be able to get a loan from anybody. Now, could mom and dad gift the money? Is there a difference in lending the money and gifting the money? Maybe mom and dad could gift it. The lender would make them sign something saying it was a gift and they don't expect to be paid back. If mom and dad lie, that's called loan fraud. Loan fraud is bad. So if the home doesn't appraise, it's not over yet. We try to renegotiate the purchase price. We see if the buyer has money laying around that they can make up the difference. If the answer is no to all of that, then we're not going to get loan approval. And if we can't get loan approval, we can't close. So what's been happening in this crazy market we're in, let's get down to a more sweet point. So now we have a purchase price or a list price. It's on the market for $250,000. The buyer comes in this crazy market and offers $315,000. This is our offer price. The buyer's got to know that it's not going to appraise. I mean, you come in, what, 85,000 over asking price. They've got to know that this thing isn't going to appraise. So what's been happening in this market lately, there's been a new form that's been created by lots of firms. Lots of firms use the form now, and it's an appraisal gap addendum, which pretty much says, I understand this home isn't going to appraise, but I got the money to cover it, and I'm not going to, anything that doesn't appraise for anything up to X amount, then I'm good, and I will still buy your house. That allows some assurance to the sellers that when in this situation this doesn't appraise, it's not a matter of if, when it doesn't appraise, this offers some assurance to the sellers that the buyer won't terminate because of the appraisal. Buyers are coming into this with money out of their own pocket. Where are they coming up with $85,000? I have no idea. I say good for them. This is in addition to the higher due diligence, the highest earnest money. I'm not those people out there right now trying to buy a house because I don't know where they're getting this kind of money. Good for them. I'm happy for them. Yes, ma'am.
I was just going to ask really quick. So you had said, which I've heard this before, you said some firms have created this form
Through their attorney.
Oh, okay. So the firm hired an attorney.
Yeah, that's why I was like the firm, yeah. So the firm hired an attorney to create a form for the firm to use.
Gotcha. Because I have heard of that. I actually have a buyer that has to have that. And so our firm hasn't like created that. So the best way like that we've done it is like put in like that I forgot what the form is called, like
Your
that
additional provisions addendum.
Yep.
Yeah, you put that in.
Mm-hmm.
And that may work as well. And again, let me rephrase. Firms should be have an attorney create that form because that's a form used for legally binding purposes. So I can't guarantee that all firms are doing that. But when it becomes an addendum, it becomes a legally binding document. So they should. So yeah, Tatiana, that may, and get with your BIC just to make sure, because we want to do what's best for your buyer, of course. But they may recommend you use that additional provisions addendum where you can kind of put in that anything else verbiage, so that anything else verbiage could be include your appraisal gap. So the loan to value ratio, again, through the eyes of the lender. To calculate the loan to value ratio, the lender just takes the loan amount and divides it by the value. And again, this answers the question to the lender of this loan amount, how much do they want from me? So in our previous example, I think we had a purchase price of 850. I don't remember. Let's just pretend that's right. So that 850 is your value. And let's say you're asking the lender for, I'm making numbers up as I go. You're asking the lender for a loan amount of $75,000. So now the question is, through the eyes of the lender, what is their loan to value ratio? So we take that 755 divided by 850,000. Whoops. We get, through the eyes of the lender, I'm just going to say it, 89%. I know that's really not going to happen, but that's a problem with making numbers up on the fly. Through the eyes of the lender, their loan to value ratio is 89%. So what the lender's saying is, of the entire value of this home, I will bring you 89% on the day of settlement for the purchase price. So now we have the buyer bringing a down payment of 11%. They're bringing the difference. Lenders bringing 89%, buyers bringing 11%. Who has the bigger interest in this home right now, today? It's not the buyer, is it? I mean, their little 11% is cute and all, but who's the one bringing the money for us to buy this home today? It's the lender. They're bringing the money. So they do have an interest until you get this paid off. Your other option is to buy $850,000 in cash. Again, if you're those people, I say, good for you. Good for you. Through the lender's eyes, The higher the loan to value ratio, the lower the borrower's down payment and the more risky the borrower is. Again, our previous example, 89% is a high loan to value ratio. That buyer is considered risky because they're only bringing 11%. Now, if your loan to value ratio was lower, let's say it was 50%, that means you're bringing half and the lender's bringing half. Bottom line, you guys, through the eyes of the lender, they have to answer the question, if this borrower defaults, can I get my money back? Can I sell the home for the amount of the loan and get my money back? So the more you pay off, you pay down that loan amount, that loan to value ratio, the less risky you get, the less risky you get, the less risky you get. Because through the eyes of the lender, if you're down to 50%, pretty sure I can sell your home for 400 and something thousand, right? And get my money back. I think we sometimes tend to think of borrowers defaulting years into home ownership. But understand, I've had lenders tell me that they have borrowers that have never made their first mortgage payment. So the lender's got to ask themselves on day one, if I never see a penny from this borrower, can I sell this house and get my money back? And that's what the loan to value ratio is helping the borrower determine. The lender determine is the borrower's risk. So when it comes to qualifying a buyer, again, if your lender's not available, you've picked up a new buyer and they want to see something tonight after class, and you can't get in touch with your lender until Monday morning, you may want to consider doing a quick qualification just to make sure it looks like it's worth your time and going to show them this property. So for us to do a brief qualification, we need to consider a couple different things. First off, we need to look at the different qualifying ratios for conventional loan and FHA loan. Let's just focus on the conventional loan ratios. And by the way, this is a math question on your test. So let's talk first about the 28% ratio. The 28% ratio looks at housing expenses. Housing expenses consider PITI, PMI if applicable, and HOA dues if applicable. So on the conventional loan, 28%, the 28% looks at the borrower's housing expenses. And what the lender falls under the category of housing expenses is your PITI, principal and interest, taxes and insurance, PMI and HOA. What the 28% ratio with housing expenses says, let's pretend that this is pi, and let's pretend that this pi represents the borrower's monthly income. And what this first ratio says, of the borrower's monthly income, the lender can allow 28% for housing expenses. What are housing expenses? PITI, PMI, and HOA dues. So everything your borrowers bring in this month, 28% is allowed to go towards housing expenses. Then we look at our second qualifying ratio, which is the 36%. The 36% ratio looks at housing expenses, which we just defined, and the borrower's reoccurring RECU. Yeah, is that right? RECURR. Is that okay? Yeah, I do math, I don't spell. So when I misspell a word, just pretend it's right. Okay. All right. So the 36% looks at housing expenses plus the applicant's reoccurring debt. Reoccurring debt are those monthly bills you sit down and pay month after month after month. Credit card bills, medical expenses, student loans, child support, alimony. What are those bills that you sit down and pay month after month? The car loan, that's considered your reoccurring debt. And again, what the lender says is of your entire monthly income, we will allow a borrower to use of their whole income. We will allow a borrower to use 36% to go towards housing expenses plus reoccurring debt. So the first step in qualifying a buyer is understanding what those numbers mean. In order for a buyer to qualify for a loan, they have to qualify under both the 28% and the 36%. In this country, what affects most of us, what eliminates a lot of people from not getting the loan, is that reoccurring debt. We like our debt here, don't we? We really, really do. And that's what hurts a lot of people. So what if you don't qualify? You may not qualify under that 36%. So what's the easy solution? Just pay off your debt. No big problem, right? Well, if you could have done that, you would already done that. Yes. Another easy solution is just make more money. If you make more money, then you can have more go towards housing expenses and debt. Okay, enough easy solutions. What are the realistic solutions? Maybe this house that we're looking at is too big. Maybe we need to reduce our price point, thus reducing our housing expenses, right? There's lots of factors going in here. And what I do know is that if a buyer doesn't qualify under the 26 and the 28 and the 36%, a good lender is going to work with them to help them get here. Because a good lender, if I can help you get your credit cleaned up, and it takes us 3 years, who cares? But I can get this cleaned up, and 3 years from now, and that buyer's ready to buy, aren't they more likely to call the lender to allow them to get to this point, that help them to get to this point? So a good lender's not going to say, sorry, you don't qualify, best of luck to you, guess you're going to have to rent. A good lender is going to say, you don't qualify, now let's talk about what we can do to get you there. Questions so far, the 28 and the 36%. By the way, keep in mind, of your monthly income, all we've done at this point is paid housing expenses and reoccurring debt. The reason they cap these things off, you still haven't eaten dinner yet this month. You haven't put gas in your car. You haven't paid utilities, water, internet. You haven't run out and bought a new pair of jeans. All you've done is paid housing expenses and reoccurring debt. And that's why they got to cap it, because they know there's more to life than paying bills. Like I said, we haven't eaten yet. We haven't put gas in our car. So the rest of this is allowed for us to do the things in life that we need to. The 31% and the 43% of FHA loans work the same way. That's 31% housing expenses allowed as part of your monthly income, 43% reoccurring debt and housing expenses. So the number's just a little different depending on the type of loan. So there's a couple different math problems that we may see tomorrow. Well, you're going to see one of them on this type of math, but there's a couple different problems that we may see tomorrow. So let's talk first. We're going to walk through a couple examples. And I encourage you guys to jot this down real quick. We're going to call these your formulas. So you want to jot these down real quick, and then we'll talk about what all it means, and then we'll look at an example together. So the first problem you may see, the problem is going to ask you about the maximum payment allowed. And when we're talking about the maximum payment allowed, we need to run the numbers twice, once with our 28%, once with our 36%. So the 28%, we're going to use our monthly payment. Please note this word monthly, I said payment, monthly income. The problem may give you annual income. Is that what I want to use here? No. So how do I convert annual to monthly? Just divide by 12. That's right. So you got to read. Words matter, you guys. So when you see annual income, or if you see annual income, divide by 12 to get monthly. Everybody good so far? So the first calculation we're going to do is our monthly income times the 28%. That's our housing expenses. How much are we allowed for housing expenses? The second, the 36%, looks at housing expenses plus reoccurring debt. The lender wants to do a true side-by-side comparison of just housing expenses. So for the second ratio, we're going to take our monthly income times 36%, and then we're going to minus our reoccurring expenses. By deducting our reoccurring expenses, we're looking at housing expenses versus housing expenses. So we're looking at housing expenses by the 28%. We're looking at housing expenses and reoccurring debt with the 36%. But now we're going to deduct the reoccurring expenses. So we got housing expenses versus housing expenses, apples versus apples. So now I have two figures. I have two allowable housing expenses. And the question is, which one will the lender approve? When you are asked for the maximum housing expenses, I always consider this opposite world. When you're asked for the maximum payment, the lender is going to give approval on the lower of the two numbers. Stop for a second. Let's ask ourselves, which borrower is less risky to the lender? The one that has more housing expenses or the one that has less housing expenses? And the less risky one to the lender is the lower of the two. The less debt you have, the less risky you are. The less your housing expenses are, the less risky you are. So when the problem asks you for maximum payment, the answer we want is the lower of the two numbers. Everybody have this jotted down. We're going to look at an example together. Can I erase the blue? We're good? Okay. So let's look at an example together. Brian has an annual income of $35,000 and his wife Margaret has an annual income of $38,000. Their reoccurring obligations are $700 per month. What is the maximum payment they can afford using our 28-36 qualifying ratios? So let's look first. Let's just focus first on the 28%. To find either one, I need to find their monthly income. So the problem tells me that Brian has an annual income of 35. Margaret has an annual income of 38. So together their annual income is $73,000. We don't want annual income. We want monthly income. So we're going to take their annual income of $73,000 and divide by 12 to get their monthly income of $6,083.33. How much do Brian and Margaret make a month? $6,083.33. Questions so far?
This is gross income, is that right?
It's probably going to be gross, yes. Yep. And that's another reason why we have to cap off housing expenses and debt somewhere, right? They haven't paid taxes yet either. That's why they cap these things off at this 2836. So we have money to do other things. People that are maxed out or at the tippy top of their loan approval amount are sitting at this 2836%. Okay, so we have their monthly income. So let's look at our 28% first. If I take their monthly income, we times it by 28%. We have housing expenses under the 28% of $1,703.33. So we ran the two ratios, housing expenses, how much can they afford for PITI, PMI if applicable, and HOA dues if applicable. $1,703.33. That's looking at the ratios. The second ratio looks at their housing expenses and their reoccurring debt. So we're going to use the same income. We're talking about the same borrowers. So we're going to use the same income. And this time we're going to run it using the 36%. So their total housing expenses, I'm just going to round here, 2190, is their total housing expenses plus their reoccurring obligations. For the lender to do a true side-by-side comparison, apples to apples, they want to look at housing expenses and housing expenses. So once we run that ratio under the 36%, now we need to come in and deduct the reoccurring obligations. So we have our 2190, we deduct our reoccurring obligations. So now what we have for housing expenses is $1,490 just for housing expenses. Opposite World says this buyer will be approved on which one? This $1,703 or the $1,490? Thumbs up for 1703, thumbs down for 1490. What do we think? Their approval is going to be the lower of the two, which is the 1490. So what's their maximum allowable housing expense payment? $1,490. Again, which one is less risky to the lender? The one that has a higher housing expense or the one that has the lower? I think when we do these lender problems, it's best to see it through the eyes of the lender. Questions on this one? We just saw for housing expenses. The problem comes out as maximum payment. Because again, that's what the lender cares about, getting their payment. Questions on this one? Can I erase? Anybody has this? Another type of question that you may see is going to be asking for the minimum monthly income. So now we're going to be provided with the housing expenses. We're going to know what the projected housing expenses are. And the question is, based on the borrower's minimum income, can they get approval for these housing expenses? So again, take a second to jot this down, and then we will talk about it. Okay. So now we're going to be asked to solve for the monthly income. So now we're going to take the housing expenses, PITI, PMI, and HOA, and we're going to divide that by 28%. So that's going to give us our monthly income allowed for these housing expenses. And then we're going to run the second set, the housing expenses plus the reoccurring debt. We're going to look at everything, all the debt, and then divide that by 36. So again, we're going to have two numbers. We're going to have a monthly income under the 28%. We're going to have a monthly income under the 36%. The question is going to ask for the minimum income allowed. And again, opposite world says the answer. What are we going to get approved on? The higher of the two numbers. Through the eyes of the lender, which borrower is less risky? The one that makes more money or the one that makes less money? And the less risky is the more money. The dream borrower makes a lot of money and doesn't have any debt, right? That's what the lender wants. The more money you make, the less debt you have. So opposite world, minimum income, we're looking for the higher of the two numbers. Y'all ready to do an example? Yeah, please.
Because I have quite a few buyers that they may qualify for like, high amount, right? But then they're like, well, I can only realistically, like that payment monthly is like super high. So my thing is, why do they approve you for so much more? Is it because they don't take in consideration the other things? That doesn't make
Well, they
sense.
kind of have, right? So let me answer that in just a minute. So remind me, we'll come back to that. No, you're good, because it's a great question. And I
Okay.
do want to have a conversation about that. So, and my little brain sometimes, Tatiana. So let's work a problem, because I do want to address that. So we'll come back to that just in 1 second. But in the event I forget, you make a note to help us remember. All right. So everybody have this jotted down? So here's another problem for you guys. And actually, you know what? I'm tired of having all the fun. So I'm going to give you guys just a couple minutes based on the formulas we just gave you. Take a couple minutes and, work through this. And then, of course, we'll come together and talk about it. And then we'll address Tatiana's question. You guys get something? Are we ready to talk about it? We need a minute? We good? Okay. First thing I want you guys to do when you see any problem, just read it. Just read it. This one says Charles and Hannah want to buy a home with a PITI of $1,900 per month. PMI will be $60 per month. HOA dues are $600 per year. Their recurring debt is $1,100 per month. What is the minimum monthly income needed to qualify using the ratios? So the first thing we're going to start with is the 28% that focuses on the housing expenses. So let's talk about our housing expenses. I know we have a projected PIT payment of $1,900 per month. This is assuming they buy this house. If they want a lower PITI payment, we need to start looking at a lower price bracket. Okay, so the house they want to buy, their dream home, gives them a PITI of $1,900 per month. PMI is $60 per month. $60 a month. And then HOA dues are $600 per year, which means we need to take that $600 and divide it by 12. So monthly HOA dues are going to be $50. So when we add up their housing expenses, PITI, PMI, and HOA dues, we get housing expenses of $2,010. So looking at our first ratio, we take our $2,010 housing expenses, we divide it by 28%, and we get monthly income of $7,178.57. That's looking at the first 28%. Questions on how I got the $7,178.57? We're good? Okay. Now we're going to look at the second ratio. Second ratio looks at housing expenses, which we just decided was $2,010 plus reoccurring obligations. The problem tells me those reoccurring obligations is $1,100 per month. So we add housing expenses and reoccurring obligations. We get $3,110. We're going to run our 36% qualifying ratio to get income under this ratio of $8,638. With opposite world, which one will they be approved on? Which monthly income are they approved to purchase this property? Let's see, 1 thumbs up, 2 thumbs up for higher, 3 thumbs up. Sounds like we're on the same page. What's the minimum income they must have in order to qualify for this loan? Their minimum income is the higher of the 2 numbers, which means they will have to make $8,638.89 for approval. To qualify a buyer, pretty much comes into debt to income, doesn't it? How much debt do you currently have? How much debt do you hope to get when you buy this house? And let's compare it to the income. So what does all this mean for Charles and Hannah? If they don't make that monthly income, then again, the simple solutions: pay off your debt, make more money. If those aren't feasible right now, maybe we need to change Charles and Hannah's price point and getting them into a lower where their housing expenses are a little bit less. So it's not over yet. This just gives us an idea of where we're starting. Again, it's important that we understand there's a common misconception out there. People think that what they pay in rent equates to what their mortgage payment will be. And rent and mortgage payment are 2 totally different things. So when your buyer looks at you and says, well, this is how much I pay every month for rent, so that's how much house I can afford. Why don't y'all sit down with a calculator real quick and run these numbers, like I said, to make sure it's worth you spending your time with them this weekend before you can get in touch with the lender on Monday. Everybody understand, ideally, we want to get them to the lender. I'm not trying to take the job of the lender here. But this is in the event we can't get to our lender. We know we're in a very swiftly moving market right now. You may not have time to call the lender to go show them this house before it goes under contract at, 4:30 today. So it's swiftly moving. And I would think that we'd want to be able to take the time, the few minutes to be able to calculate on these numbers. So what I've done now, if you'd like, is just a nice side-by-side comparison of the two types of formulas that we ran. I got a little bit of practice for you guys, but if you want to see these again side by side. For tomorrow, I would focus on the one on the left. Excuse me, my goodness. What was that? I got a little bit of practice for you guys. I'll show you where that is in just 1 second. Before we do that, though, let's go back and pick up Tatiana's question. So thank you for that. And the question is, the lender says you're pre-approved for X amount. The lender says you're pre-approved for a housing payment of X amount. And the borrowers go, oh my gosh, I'm not comfortable making that payment. Part of it may not be that the lender has all the information yet. When we first start talking, or when your borrowers first start talking to a lender, there's a couple steps in the approval process. The first step in the approval process is a pre-qualification. And a pre-qualification is when the lender asks the borrower, what are your current expenses, what's your debt, and what is your income? And based on the numbers submitted by the borrower, the lender submits a pre-qualification. They don't verify those numbers. They don't check those numbers. They don't say, are you sure those are all your numbers? They rely on what the borrower told them. So if the borrower estimated their income, or if the borrower guesstimated their expenses, we may have an approval that's not, or a pre-qualification, I should say, that's not reflective of what they'll actually be approved of. So trying that borrower to get, be very honest to get that pre-qualification. The pre-approval is taking the pre-qualification a step further. Now the borrower is sending the numbers, this is my income. And now the lender is verifying those numbers. We're going to run your credit. We're going to pull the numbers. We're going to look at your credit history. We're going to take it a few steps further and verify those numbers from accuracy. So right there, Tatiana, that might be a big difference, is how accurate the borrower was when they reported those numbers versus the lender verifying those numbers. I think another piece of that, the numbers that the lender, the pre-approval amount that the lender gives the borrower is the max that they're allowed. And I think some borrowers see that and they say, oh my goodness, no, I don't want to max out. I don't want to be house rich and not be able to afford to do anything else. So I appreciate you, lender, approving me for $400,000. That makes me nervous. I think I'm going to back off and look at a $200,000 home. So I think that's what happens in a lot of cases. The lender gives you the max, the tippy top. It's going to be up to the borrower if they are comfortable with being up to here or if they'd rather live down here a little bit. On that same note, I had buyers once, I think they were pre-approved for 285. They weren't looking at anything under like 275. Like, no, this is how much the lender's giving me. This is how much we're going to spend. They made me nervous. They made me very, very nervous. But this is what they're going to give me, and I'm going to take it, by golly. So these are the houses we're looking for. As their agent, what's my job? Show them the properties that they want to see, as long as they can afford them. So where they land in that range from high to low, that's got to be up to their comfort level. Hopefully understanding the risks of maxing themselves out. Because again, if you're house rich, you're poor everywhere else, aren't you? Anybody like to take a vacation this year? Maybe. Yeah, if you're maxed out, that's going to get tricky. You want to buy a new car? What, your hot water heater blows up? I mean, there's all sorts of things that could happen that we may want some wiggle room in those payments. What other questions do we have? Qualifying a buyer, having that basic understanding. Just a little bit more in chapter 13. Skip ahead to 437. Tatiana, you're looking for major types of residential mortgage loans. So just a brief conversation about the different types of loan products that might be available to the borrowers. Conventional loans aren't backed or secured by the government. So with a conventional loan, the lender doesn't have the safety net of the government in the event of the borrower's default. The lender bears the risk. So if the borrower defaults, the lender's got to save themselves. They got to protect themselves. One way that the lender protects themselves for conventional loans, they may charge PMI insurance, private mortgage insurance, PMI, when the loan to value ratio is 80% or more. So conventional loans, loan to value ratio is 80% or more. The lender may charge insurance. Insurance protects us if something bad happens. Yes. So PMI insurance is protecting the lender if something bad happens. Through the eyes of the lender, what's that something bad happening? You stop paying them. You default. Once that once that loan to value ratio drops below 80%, most lenders will drop that PMI insurance because you're not as risky. Again, the question is, if you don't pay me back, can I sell your house and get my money back? And once we fall under that 80% threshold, the lender feels satisfied that they can. Conventional loans tend to be conforming or non-conforming loans. If they're conforming, they satisfy certain guidelines, certain criteria that the markets that buy the primary loans, the markets that purchase the loans, the conforming loans are attractive to those markets. They're a sellable loan. They have the bells and whistles, the guidelines and the criteria that those loan purchasers are looking for. If they're non-conforming, then they don't meet those guidelines and they can't be sold. Some lenders keep their loans in-house. Not all lenders sell their loans. Where are my homeowners on the call? Current homeowners. You guys have your current lender? Where's your loan been serviced? Loan's been serviced, both. Yeah, me too. Yep. And sometimes by, like a month, if that, weeks after closing. And buyers call me and they say, dang, they couldn't get rid of me any faster. I don't understand. I thought they liked me. No, they love you. But one way they can keep their pool of money coming in so they can lend it out is by selling your loan. Consider this, guys, lenders don't have like this endless supply of money, right? They don't have a money tree out back that they can go pluck $100,000 bill when you want to go buy a house. So the lender's got to get money to give to you. And one way that the lender might get money is to sell the loans, service the loans. It replenishes their funds and it allows them to originate new loans, which helps keep money flowing in the economy. Real estate is a great place to keep money flowing in the economy. Other types of loans are government-backed loans, which means the government insures and protects the lender in the event of the borrower's default. The government is offering a safety net to the lender. And they're saying, if this borrower defaults, I'm here to catch you. I'll help you out. As you can imagine, because the government's involved now, the process to get an FHA, VA, or USDA loan just got a lot more strict, didn't it? Borrowers have to jump more hurdles. They have to jump through more hoops to get these types of loans, because the government's not going to secure or back just anybody. So there's higher qualifications, higher criteria. Also with these types of loans, it's not just getting the people approved. The properties also have to meet certain specifications. If you ever start working with an FHA, particularly an FHA or a VA buyer, you may want to consider going to their websites, FHA and VA, and you can find a list of things with the property that probably won't get it approved for an FHA buyer. So when you and your buyer are standing in that house, you can look at your list and say, I'm not sure that we'll get approval because condition of the property. Examples of things that they're not going to approve. A 40-year-old roof, not going to do it. What about chip paint when the property was built prior to 1978? What are we dealing with now? Potential lead. You're not going to get approved. Apparently kids, dogs, pets, they all like to lick chip paint, apparently. And when it's chipped and laying around and it's not intact, it's a risk. So you're not going to get approval for things like that. This list changes on the regular. So again, when you get this FHA buyer, go to the FHA's website and look at the list, have that with you. Same thing with VA. USDA loans are for our rural areas, our agricultural farmland areas. Again, government involvement, higher, stricter criteria, more hoops and hurdles to jump through. Questions on the loan piece of it? As mentioned, qualifying a buyer is going to be on your test tomorrow. So I have an extra little worksheet here for you guys if you want to do some extra problems tonight. Of course, I've included the solutions. So if you want a little bit extra practice, you're picking your calculator up twice tomorrow afternoon. Once for the income capitalization approach, and again to qualify a buyer. Also remember for your test, basic calculators only. Please don't bring your phone tomorrow. I cannot let you use your phone. I can't let you use the calculator on your computer. John, that thing's kind of fancy. That doesn't store formulas, does it? You don't know? I may ask you to hold your hand up and say, Julie, I have no idea how to store formulas on this thing. Pinky swear. All right. So some kind of, again, off phone, off device calculator, the more basic, the better. We have to do a little check-in process tomorrow for the test. So one thing I'm going to want to see is your calculator. Yes, you can have scratch paper tomorrow too. I'll never ask you to do math without scratch paper. I'll never ask you to think without scratch paper. Sometimes I got to think on paper. Anybody else? Yep. Helps keep things sorted, doesn't it? So we'll do a little check-in before your test tomorrow. We'll talk about that tomorrow. Any questions? Qualifying a buyer. You're also going to see a sales comparison approach tomorrow, but you're only going to have to make like one adjustment, right? So don't worry about doing like your homework assignment. We don't have the time for that. So it's going to be very, very quick sales comparison approach. And we're all good that our homework assignment is due by tomorrow morning. Homework assignments are due by tomorrow morning. Right. Let's take a break. I got 3:40. We'll come back at 3:50. Probably get wrapped up with working with buyers today. Welcome back. We're here for the last hour of the next to last day. You're good. Breathe. You're good. Okay. So, qualifying a buyer. You guys have all worked with buyers. Has this ever come up, or we've been able to get your buyers to lenders as soon as possible? Have you been able to get your buyer to a lender? I think that. So like I said, you know, it used to be, seriously, you guys, it used to be our lenders worked a strict Monday through Friday, 8 to 5. They got an hour lunch break. You know, at 5:01, you weren't getting in touch with a lender. Evenings, weekends, that kind of thing. But today, I think the lenders evolved. I think the lenders have decided that if they want to be competitive, they got to work when we work. We're out there doing evenings and Saturdays and Sunday afternoons, aren't we? So if they want to be competitive, if they want that business, they got to be available to us. So I say all that to say, I think most of the time you're going to be able to get them to a lender. However, there may be a time where you need to run a quick qualification just to see if it's worth your time to go show them that home. And that's when you can use this until you can get them to a lender. Please look at some number before you take them out and show them property. Not numbers that they provide you, but some number. You'll save yourself some time. Agents have a reputation of just showing property, and I need us to stop that. So y'all promise me, you're not going to work with a buyer until you've looked at some number. Promise? Thank you. I got Boy Scouts honor from John. Thank you. It's for y'all. It's just as much as it is for them. So back to, again, hopping kind of around, back to specifically working with buyers back in chapter 9, we've gotten them pre-approved or pre-qualified, or at least we've crunched their numbers. Now we're ready to start selecting properties for showing. And same thing with sellers. Same thing as working with sellers. And I think more importantly than working with buyers, always remember safety first. If you don't know this buyer, you need to take some protocols to make sure you are safe. Maybe you have somebody come with you. Maybe you have them meet you at a public place. Meet me at Starbucks so we can talk about what you want to buy before we go out and see it. While you're sitting at Starbucks, what a great time, a great opportunity to work with real estate agent disclosure. You can use that as an excuse to get them in a public place. If they're not willing to meet you at Starbucks for a coffee, I have to wonder their intentions. At the end of the day, no commission is worth y'all's safety. So always keep your safety in mind. So we feel safe. We're working with these buyers. Now we're going to take them out, schedule and show properties. Most of us across the state use some kind of centralized showing system. Here in the Triad and Canopy, ours is called Showing Time. You may have a similar program that does the same thing. I'm getting ready to date myself. When I started in real estate in 2001, we didn't have Showing Time. We didn't have this idea of a centralized showing system. So if you wanted to schedule, if you wanted to show a home, you had to contact each firm. The firm would confirm the showing through the listing, and then the firm would call you back to either confirm or deny the showing. So remember that scenario a few minutes ago, we were talking about taking buyers out on a Saturday and showing them 13 properties. If those 13 properties are with 13 different firms, that meant you had to call 13 different firms to schedule those showings for your buyers on that Saturday. When I started in real estate, that was my job as the receptionist, was to answer calls from buyers agents to schedule appointments. And then I would contact the sellers to get that appointment approved. Today, We are blessed with showing time. Want to schedule 13 appointments to show in one day? You just got one place to go, one source to go. That's right. John's over there clicking on showing time. You just jump on that one site and you can request all those showings in one place. Who knows what we'll have tomorrow? There's got to be something bigger and better waiting for us afterwards. But anyway, we got to schedule the showings, trying to work around their schedule, trying to be accommodating to their schedule. Remember too, we try to want to give the sellers time. Some sellers require time for showing. Some sellers require an hour notice. Some require 24-hour notice. All that will be spelled out in showing time, your showing instructions. When you go to schedule the appointment, you will get access to the property once you get a confirmation of that showing. So once the seller says that showing time's okay, that's when they'll send you the access. So we're showing the properties to our buyers based on their wants and needs. Again, you guys, just be prepared for those wants and needs lists to adjust and to pivot. They may think this is what they want, but once they start seeing the products that are available in this market, they may have to adjust. So help them see what they're not. Please always remember, as a buyer's agent, you're not the one buying this house. So you shouldn't be go through this going, gee, what is my family? How did my family look here? This isn't about you. This is about helping your buyer get in the right home. I think, or I know, when buyers first look at a home, they're looking at the big picture through rose-colored glasses. They're walking in the front door, looking at how their family can fit in this home. You know, can I see ourselves doing Sunday brunch and Friday night game night and all the things that the family does together, all the things that the family does separately? Do I have a little room that I can have alone time, you know, kind of thing? They're looking at how their family dynamics fit in this home. You and I need to be helping them look for everything else. Is there a crack on the wall? Is there a water stain on the ceiling? Is the carpet buckled? Is the whatever. We're not there looking through it through the eyes of the potential to live there. I learned this lesson the hard way. So I was with a buyer once, and her and I were out on a Saturday. We were only looking at about 3 or 4 properties that Saturday. But we walked into a home, and it was a nice home. It was lived in, it was loved, but overall it was a nice home. And we walked in the kitchen, and my buyer was looking around the kitchen, you know, can I see myself fixing meals for my family in this kitchen? Can I see us doing this and everything else? I happened to notice every single baseboard of that kitchen had been gnawed on. These sellers had a really big dog, and that dog had to gnaw and scratch on the baseboards on the kitchen. And I happened to say, haha, you'll have to replace the baseboards. And my buyer was like, what? Huh? What was that? I'm sorry, come again? Baseboards, they're not on? Oh, I didn't even see that. How did she miss it? Because she was looking at the kitchen as a whole. She wasn't looking at the specific details. Does that make sense? So that was my, dang, I need to be their eyes for the things that they're not seeing. Help point those things out. Every time you can get them in that property, once we get them under contract, if you can get them back to do, I don't care, furniture placement or look at paint samples, or maybe mom and dad want to come check it out, the home inspection, every time you can get them back in that home, they see something that is different that they didn't see the time before. So I am a firm believer in getting a buyer in the home a couple times while we're still in due diligence. Obviously, through a scheduled appointment with the showing, we just can't show up. We need to schedule that time through showing time with the seller, so let them know that we're coming. Also, make sure before showing, if you're showing outside of your MLS, or if the commission offered to you within your MLS isn't what your firm expects to collect, then you work out those commissions before the buyer says, I want to write an offer. Remember that 0.5%. If my buyer bought that house, they would have to ante up some money, right? I had this conversation with my buyer. before we ever went and saw the listing. We were all still sitting at home. We hadn't pulled up in the driveway yet. Because here's the deal. If I waited to have that conversation and my buyer walked in the front door and fell in love, said, this is the dream home, I want to buy this one, and then I start babbling on about commission and you're going to have to pay me money, they're not listening to me. They're already placing furniture and figuring out when and where they're going to move in. So have these conversations with your commission while your buyers are still thinking clearly. Again, protecting your commission. And then as mentioned, you and I are also going to be the ones scheduling the showing appointments. So not only what they want to see and when, you know, and if you're doing like a couple in a row, you know, let's say you're even doing 5 in a row. If it happens in the middle of lunchtime, you may want to consider a little lunch break. If you're doing 10 properties today, you want to plan on a potty break here and there, right? So plan your day accordingly. Triad MLS has a phenomenal tool. And you can go in, if you're showing 10 properties today, you can go into Triad MLS, put in those 10 properties, and it'll map it out for you. So you can decide in what order you want to go, what makes the most sense driving wise. But it also tells you the distance in between properties. So if it's going to take you 15 minutes to get from A to B, and you know we're going to spend 15 to 30 minutes in A looking at it, that helps you know when to schedule property number 2. What's the difference from property number 2 to property number 3? So using those tools can help you schedule those showings, help schedule that day of showing. Again, taking driving time, potty breaks, lunch breaks, everything into account in between. You guys haven't been able to do that much because we've been in the seller's market. What are you guys doing? Running out, showing a house at a time? Meet a buyer, show a house, meet a buyer, show a house, meet a buyer, show a house. Is that pretty much what you're doing? Have you done back-to-back showings? A couple of you. Have you done 13 in a day? You have? Oh, good. That's fun. That's fun. We're coming back to that. Again, is that pendulums, you don't think that's fun? That's the part of it I enjoy the most. Going around looking at pretty houses, you know? As that pendulum swings back, we're going to see a stronger buyer's market. There's going to be more inventory. It's not going to be a property that they're interested in. It's going to be, you know, 20. So how can we get all these in? And it's not as swift moving either. Yes, ma'am.
Oh, nothing. I was just gonna say, if you have 13, there's a higher chance of them liking at least one of them, and then you go ahead and submit an
Thank
offer.
you. What a great way to cap off that day by going home and writing an offer. Yes? Agree. Agree. As a buyer's agent, as a listing agent, as a seller sub agent, as a dual agent, as a designated agent, I don't care. We always have a duty to discover and disclose material facts. I hope this is ingrained in your memory at this point. We always have a duty to discover and disclose material facts. Buyer's agents, this duty to discover and disclose material facts might be a little higher for buyer's agents, because not only are we disclosing what we know, we're also helping the buyer discover things that we don't. And that's where you and I are going through the home and looking through the things that the buyer isn't necessarily seeing. So helping them discover, disclose what you know. When it comes to material facts, we have no secrets. We always disclose what we know. And then we got to discover, we got to ask questions, investigate, pay attention to those little red flags, etc. Inspections are one way to help the buyer discover issues, problems with the property. Generally, the home inspection will be the first one ordered. The home inspector, their job is to come in the home and point out all the problems with it. Prepare your buyers for this. The home inspection report is not going to tell your buyer what a lovely home they're buying. The home inspection report is going to tell them all the problems. If, for example, there's an electrical issue, the home inspector will suggest that they talk to an electrician. They may tell them to talk to a plumber, general contractor, structural engineer, whatever the issue may be. But inspections are a great way, particularly home inspections are a great way to discover, disclose those material facts. Also making sure the importance of doing the final walkthrough. Seriously, on your way to the closing attorney's office, the last thing you do before you go to the attorney's office should be to meet your buyers at the house on the way to do that final walkthrough. If there's an issue discovered at the final walkthrough, we need to address it. We need to take care of it before your buyer signs. Because there is a sentence in the contract that says, signing constitutes acceptance of the property in its then current condition. So if there's an issue, please don't tell your buyer to sign and we'll figure it out later. If there's an issue, we got to figure it out before they sign. I always tell my guys to have a plan B, because I never want to put my buyer in a situation where they feel like they have to sign today and accept the property in this condition because they have nowhere to stay tonight. So if they have a plan B, they won't feel forced to sign. I don't want anybody sleeping in the U-Haul tonight. That probably wouldn't be comfortable. So have them have a plan B just in case. Another thing we're going to do with the buyers that we also do with the sellers, but we're going to do with the buyers as well. We're going to pull a CMA. Why am I pulling a CMA for a buyer?
Did you say why are we gonna
Why?
be?
Oh, I'm sorry.
Why is this important for a buyer?
To make sure that he is paying a decent amount, maybe. Maybe putting a
Maybe
CMA.
paying a decent amount? Yeah, I could
Not
agree with
overpaying.
Yeah. Tatiana, what were you going to say?
Oh, no, nothing. Basically the same thing as Kim, just determining how much they should offer on the property.
What's an acceptable offer price? So here's the deal. Buyer walks in the front door, they fall in love, they say, this is it. I want to write an offer. And then their next question is, how much should I offer? Are you just going to blurt a number out? Are you going to tell them to offer the asking price? Because you're sure the seller has it priced appropriately. No, we're going to have an educated response. This is that reasonable skill, care, and diligence that we've been talking about. So how do we have an educated response? We pull a CMA. We show the buyer the probable sales price. This gives us an idea of what it's going to appraise for, first off. So we know if it's going to appraise or not, have an idea if it's going to appraise or not. The buyer's going to have to come up with more money if there's a difference. This also can come in handy when your buyer knows they're going into a competitive situation. And maybe we determine, let's see, this CMA, we're looking at probably 143 to 151, somewhere in there. There's our range, our probable sales price. And this is a good place to start. But in this market, the buyer may say, well, I want to be competitive, so I want to offer 165,000. If the buyer chooses to offer more than the asking price or the CMA range, can they do that? Can they offer more? Absolutely. But it's our job for them to understand what the probable sales price is, because that's going to help them determine what it appraises for. If they choose to go over this, that's on them. Again, we're back to having that discussion about risk tolerance and making sure they understand what their risk, and making sure that they understand that it's not going to appraise and you're probably going to have to pull money out of your pocket. Does this make sense? This gives us a piece of paper to have a conversation with the buyers trying to decide how much they want to offer. So always do CMAs, not just for sellers, but for buyers as well. Another thing that may be important for buyers is if they need to determine any land use restrictions. Part of what we're doing when we're spending time with and meeting buyers is hopefully helping to learn their end use. Why are you buying this property? What do you want to do with this property once you buy it? And so if we know their end use, we now can help them verify that their end use is allowed. So making sure that they have certain representations about the property's use are accurate. This could get us into some zoning issues. Everybody wants chickens. Remember the egg craze, what, a couple months ago? Now, what's the result of that? All buyers want chickens. John's shaking his head. John, did you check zoning and make sure chickens are allowed? Did you check covenants to make sure chickens are allowed if they're in an HOA? HOA, there you go. So this is what I mean by their end use. Do you want chickens? Do you want a goat? Well, that sounds lovely, but let me help you make sure it's allowed. What if the buyer says that they want a property with a garage so they can convert the garage into a hair salon? Or if they tell you they want to use the house to run an in-home daycare. My little red flag just went up to tell me to check zoning, covenants, everything else to make sure that end use is allowed. So back to our wants and needs, having these conversations with buyers. Also seeing if the property is in a flood hazard, a flood zone. FEMA determines the flood areas, Federal Emergency Management Agency. FEMA has a map. Several sites have a flood insurance map. It's not a bad practice, not a bad habit to get into, to check the flood map before we write the offer. At least give your buyer the idea of whether or not we could be dealing with a flood zone. If the property, if the structure is in a flood zone, more than likely they will have to pay flood insurance. Flood insurance is not cheap at all. And if the property's in a flood hazard and they have to pay flood insurance, and flood insurance tips them over their allowable housing expenses, we're not going to get loan approval. So having this idea before we walk into the contract, again, I'm not FEMA, I'm not a structural engineer, but I can look at a map and say, this is close. Several different sources. I know we can access a map and try it MLS. You could just go to FEMA's website and look it up. Again, I'm not the end all be all. I'm just trying to get a general idea if this is something we need to have a conversation about. By the way, if the property is in a flood hazard, but the structure is not, they may not be subject to flood insurance. It may just be when the structure, when the house is in the flood hazard, that's what the concern is. I sold a house once and we were in a cul-de-sac and the lot was so weird. The lot from the cul-de-sac kind of came up like this. And then it did this wonky thing up here, right? I mean, it just, everybody else in the subdivision was on a third of an acre. My guys were on 5. So I feel like mine was the last one built in the subdivision and the developer didn't know what to do with the rest of this land. So they said, just give it to these guys because everybody else was on a third of an acre. So my guys had all this land and the house was like right here by the road. Back up here, and most of this land was unusable, by the way. My guys had a little campsite kind of like right here that you could hike back a little bit and go camping. And that's what they did together as a family. But they said they never came all up in here because it was all unusable land. But up here in the top part of the land was a creek. This part of the area was in a flood zone because of the creek, but it was so far away from the house that they didn't require flood insurance. So yes, part of the property was in a flood hazard, but the the structure itself wasn't subject to flood insurance. I disclosed that in MLS, and I still probably had every other buyer's agents calling me. You don't have to pay, they don't have to pay flood insurance. That's correct. So I appreciated the phone calls. Tells me I got buyer's agents doing the best they can to protect their buyers. Another thing we want to check, as we mentioned, if it's in an HOA, we want to check those covenants. HOAs tend to be a little bit more strict than zoning because HOAs are private. Zoning is public, HOA is private. So you may have a little stricter criteria in zoning. If it's going to be in an HOA, if it's subject to covenants and they want chickens, we need to get our hands on those covenants to make sure chickens are allowed. Help them make sure that their end use is allowed. Who remembers this fancy word, appurtenant? If something's appurtenant, what's that mean? See mouths move. If something is appurtenant, it runs with the land. It conveys from one owner to the next, to the next, to the next. Covenants are appurtenant. They're created when the developer creates a subdivision. They create the rules, if you will. The very first homeowner of the subdivision has to follow the covenants. The second one, the third one, the 351st one. All owners have to follow those covenants. They run with the land. When it comes to these covenants, our job is to help the buyer find them. Our job is to put these covenants in the buyer's hands so they can make sure they're good with these rules when they buy this property. Our job is not to interpret the covenants. Help them get it, help put it in their hand. But when they look at you and say, what's this mean? We either need to get them to their attorney or to the HOA. We cannot interpret covenants. Another thing to consider when working with buyers is property insurance, homeowners insurance. We need to get the buyer shopping for homeowners insurance while we're still in due diligence. So we get a buyer under contract, buyer's agents. Good job. You got your buyer under contract. First thing I need you to do is send that contract to the lender. Let the lender start doing their thing. Then you send the contract to the attorney. Let the attorney start doing their thing. The lender is going to be in communication with the buyer to gather the documentation and the information they need to get the loan through the first round of underwriting. So tell your buyer, when you first go under contract, their priority is the lender. I tell my buyers, you call the lender back before you call me back. So make sure they are communicating with the lender so they get what they need to get this loan process rolling. Once we get the lender satisfied on the first round of material, that's usually when I start having my buyers start shopping around for homeowners insurance. And again, we're going to encourage them to shop around. Don't tell them this is the homeowners insurance company you're going to use. You're going to like it. Tell them to shop around. Have them call Jake from State Farm and Flo from Progressive and whoever else you may want them to talk to. Not all insurance companies are created equal, so they're going to have different rates, different quotes, different prices. Another important reason to do this during due diligence. If homeowners insurance tips them over their allowable housing expenses, we're not going to get loan approval. Worst case scenario is to terminate. Let's just say that. Terminating is a bad day, bad day. As a buyer's agent, if we have to terminate, the best thing I can do is terminate while we're still in due diligence so I can get my buyer their earnest money back. So have them shop around for homeowners insurance, have them do as much as they can. If your buyer's getting a loan, homeowners insurance is required, period, end of story. If it's a cash buyer, homeowners insurance is highly recommended. Additional responsibilities of a buyer's agent. We're going to help them prepare their offer. We're going to go through the specifics of the offer, making sure they understand the terms. We're going to help them negotiating the offer, handling contract matters, helping buyer and seller come to agreeable terms. We're going to assist the buyer with the entire due diligence process, getting inspections and title insurance and survey and flood insurance and da-da-da-da-da. And bottom line, we're going to help prepare them for closing. All of this is to come when you get to 302, if you haven't taken it already. 302 is called contracts and closings. So in 302, you will walk through the entire contract to closing process. And also in 302, you get to do a full-blown settlement statement. So if you haven't done 302 yet, I'm getting you warmed up on your calculator, because you get to use it a lot in 302. Is what it is. Remind me, who's done? Let's see. Camille, this is your third, right? I think you're the only one. The others. Yep, the others, it's your first. Yep. So, Camille, we're going to be envious of you tomorrow about 5 o'clock, aren't we? The rest of you strive to be like Camille. Get your post done. Any questions on working with buyers? So y'all set your private chats just to me, because I got a couple questions for you guys. Everybody ready? Tell me in a private chat, A, B, C, or D. Hey, Leanne, I know we're second guessing us. This happens when you look at it for too much longer, right? Now you start second guessing yourself. So typical matters addressed in a buyer agency agreement include all the following, except these are tricky because the reason it's right is because it's wrong. So typically in a buyer's agency agreement, we could see all the following, except our requirement to disclose the terms of the buyer's offer. Remember, we never disclose the terms of an offer without the offeror's permission. And if for some reason your buyer does give permission to disclose the terms of their offer, first off, I would sit down and have a conversation with them and make sure that they understand what that means. But second off, there is no requirement, absolutely not, in the agency agreement. Questions on this? Let's look at another one. A, B, C, or D. Okay, so when a buyer's agent has an opportunity to work with a limited service listing broker, the buyer's agent, we need to be clear about the expected compensation before entering into the transaction. Limited service listings will be found in MLS, but just like any listing in MLS, there's no guarantee that the seller is willing to pay what your firm expects to collect when they work with a buyer. They may not be limiting your commission, maybe they are, maybe they're not. So what we're looking for here, maybe the seller will pay you, but definitely what we need to be is clear about those commission. Remember, all of our compensation issues need to be hashed out before we present the offer. So no matter what, full broker services, limited broker services, etc., we always need to make sure that we're clear about our commission. Questions on this one? Let's get another one. Leanne? So this one says, This one says a buyer's agent must. Boy, that little word must means a whole lot, doesn't it? It means a whole lot. A buyer's agent must make sure that that buyer is properly qualified. Presence of nearby sex offenders is not a material fact. Unfortunately, HGTV isn't real, y'all. So it's not like we're going to show these buyer 3 houses and they're going to pick which one works for them. We're not obligated to show them a certain number of homes. Maybe they fall in love with the first one. Maybe they fall in love with the 100th one. You could be with them for a week before they find one. You could be with them for months before you find one. All buyers are different. All transactions are different. So there's no certain amount of properties. And then I can't guarantee that the price is a good investment for the buyer. Cool. I can't guarantee that it's a good investment for the buyer. I can, help point them in the right direction to find out that question. Maybe I have them talk to an accountant or an investment specialist, but that's not a must for me. So making sure that they're properly qualified, may that be getting them to a lender or using our qualifying ratios. Questions on this one?
Julie, would you say that is truly a must or a should? I mean,
I'd
must
say
seems pretty strong.
In this market, I'd say it's a must because sellers aren't even going to look at your offer if you've not been qualified. So if I want to give my buyers a fighting chance, I'd say it's a must. Absolutely. I mean, in any market, even in the height of the buyer's markets, sellers weren't considering offers. You need that backing, that somebody else saying, yeah, they can afford this. Good question. I think this is the last one. Let's see. A, B, C, or D. Okay, so regarding oral buyer agency, which statement is false? Oral agreements must be exclusive. Remember, oral agency is non-exclusive. We cannot force the buyer to only date our firm in an oral agency agreement. If you want to demand exclusivity, we got to get this thing in writing. Questions on this one?
Yeah, I don't know why I thought it was B, but I'm just reading. I don't know. I'm tired. Because I didn't get it where it says our oral agreement should address issues found in the written agency agreement. I'm
Yeah,
lost.
so our oral agency agreement is express, meaning
I know
the
it's
terms
express.
have been clearly stated. So
Right.
whether or not we do that in writing or orally doesn't matter. We're clearly stating the terms. So whatever we have the conversation about, those are the terms that we're discussing is what we find in our written agency agreement. So it's
Right.
the
I
same
just guess it got
terms.
lost where it says addresses issues found in the written agency agreement.
That's right,
Because it's
because that
oral.
addresses buyer agency agreement. That addresses buyer agency. I'm just not asking you to sign anything yet. We're creating agency. I'm just not asking you to sign anything yet. Other questions? Well, that gets us through, almost gets us through working with buyers. And I want to look at one more thing. We're in the commission's website again, ncrec.gov. And this time we're under resources. And under resources, they have a video library. So when we go into the video library, we can see that they have videos for us, for brokers. If you know anybody that's wanting to apply to get their license, they have videos here. There's videos for consumers. Consumer videos are good stuff like how to file a complaint against your agent. They put it right out there. And then for education providers. But if we look under brokers, you guys can see in here, I mean, there's just, we're going to look at a few of these, but you know, if you're not sure about the renewing your license process when it comes due next year, they got a video for it. 303, y'all watch a lot of videos. You feel like you're watching videos, but you're doing things in 303 like registering an assumed name, activation and affiliation, various things. Here's safety. So again, just knowing where to find, being familiar with what we can find on the various things of the commission's website. The video I want to show right now, you can see the first two videos are working with real estate agents. And they have one video about working with sellers, and they have another video about working with buyers. So since we're just getting done talking about buyers, this is the one that I want to show right now.
Are you considering buying a house or other real estate? If
Can
so,
you guys hear it?
you may want a real estate agent to guide you through the process. Here at the North Carolina Real Estate Commission, we want you to understand the different ways you can work with an agent when buying real estate and the services agents can provide. You have several choices about how a real estate firm and its agents will work with you. For example, you may want them to represent only you as a buyer agent, or you may be willing to allow them to represent both you and the seller at the same time as a dual agent. You might even prefer to be unrepresented and work directly with the seller's agent. Some brokers will offer you a choice of these services, and others may not. Whether you choose to work with a buyer agent, dual agent, or seller's agent, that agent must treat you honestly and fairly and tell you about any material facts that the agent knows about or should know about that could influence your decisions in the transaction. The Real Estate Commission has developed a disclosure form called Working with Real Estate Agents to help you understand the different kinds of agency relationships. The form emphasizes the importance of not sharing confidential information with an agent until you know the agent represents you. The Real Estate Commission requires every real estate agent to review this disclosure form with you and to ask you to sign it before receiving any confidential information from you or assisting with your purchase. The Working with Real Estate Agents disclosure is not a contract. Signing it does not obligate you to work with the agent who presented it to you. Your signature is just an acknowledgement that you've received the disclosure form. The Commission also publishes a brochure entitled Questions and Answers on Working with Real Estate Agents. Now, this brochure explains what a real estate agent's duties are, what services your agent will provide for you, and how the agent will be paid. You can download the brochure for free from the Commission's website at ncrec.gov. If you choose to have a buyer agent or firm represent you, they owe you certain duties. First, the firm and its agents must promote your best interest ahead of all others. They must be loyal to you, follow your lawful instructions, and give you information about the property that could influence your purchasing decisions. Your agent must also use reasonable skill, care, and diligence throughout the process and account for all money they receive on your behalf. Once you've agreed that a firm or agent will represent you, they may not give certain confidential information about you to the seller or the seller's agents without your permission. Confidential information includes your motivation for buying or your negotiating strategy. For this reason, don't tell the agent anything that you don't want a seller to know until you enter into an agreement to hire the agent. A buyer agent will help you find a suitable property, gather more information about properties you're interested in, prepare and submit an offer, order inspections, and prepare for closing. A buyer agent may be paid in different ways. Often, the agent will seek payment from the seller or listing firm first, but if the seller and listing firm refuse, then you may have to pay the buyer agent yourself. You and the agent will address the firm's fees in the written buyer agency agreement. So be sure to read and understand any agency agreement before you sign it, and make sure it includes any promises that the agent has made to you. You'll also be asked to indicate in the buyer agency agreement if the firm you're hiring would be allowed to participate in dual agency. Dual agency is when the firm that represents you also represents the seller at the same time. This is most likely to happen if your buyer agent's firm has a listing agreement with the owner of a property that you want to purchase. In a dual agency situation, the firm and its agents owe equal obligations to you and the seller rather than only representing your interests. Because of this, your agent may lose their ability to advise, counsel, or advocate for either party. In order to reduce the conflict of interest inherent in dual agency, some real estate firms may offer a type of dual agency called designated dual agency. Now, this is where one agent within the firm is designated to represent only you, and another agent within the firm is designated to represent only the seller. Neither agent should have confidential information about the other party at the time of designation. This type of dual agency allows you and the seller to be more fully represented because it allows your agent to advise you and to negotiate and advocate for you. For more information about the duties and responsibilities of real estate agents, visit the Commission's website at ncrec.gov and click on the Publications tab, or just give us a call.
So they make, again, these videos available to the public. The public may or may not know these videos are here. They allow us to use them. I think if I were a consumer hearing about this for the first time, I wouldn't have my questions answered. I don't think I would have a full understanding of agency. What do you guys think? Pretend you don't know what you know. And the first time you see this video as a consumer, how do you feel about agency? You're going to go, I got this, I'm all good. I think these videos can be used as a jumping off point to talk about agency. Absolutely can't be used to supplement our discussion to agency. But if you want to use these as a place to start, they're available to you because it does introduce the consumer to things such as dual agency, designated dual agency, that kind of thing. But again, the videos can't be used to supplement our conversation with the consumers. And I want to point out, make sure we all see this because he said something very important in here. And I want to make sure again that we all heard it. I guess I just had it. He was talking about the different options working with or working as a buyer. So as a buyer, you could work with an agent that's acting as your buyer's agent or a dual agent. Did you guys hear him say or? You can't be both. If you're a buyer agent, you're exclusive to your buyer. If you make that switch to dual agency, you now share that with the buyer and the seller. So you either have exclusive representation or you allow the agent to be a dual or dual agent. Then of course your third option is working with as a customer with that seller sub-agent. So just make sure we heard that word or. Questions on anything? I'm going to call it here today. I know we're a few minutes early, but Let's talk about what tomorrow is going to look like. We're in really good shape. I feel good about tomorrow. So tomorrow, we got to have a discussion about working as a dual agent. So we'll talk about dual and designated agency. Then we're going to have a conversation tomorrow working as a property manager. Now, I know Kimberly's our only property manager on the call. She's excited. You finally get your own section. Kimberly's been patient listening to us babble on about buyers and sellers. So tomorrow morning is about you, Kimberly, for about, I don't know, 30 minutes, right? That's what she gets. So we're going to talk about a property manager, some of those roles and responsibilities. And then the last little section we have, the commission always calls other. So there's going to be some issues about your license statuses, the various license categories, that kind of thing. Homework assignments are due to me by 9 a.m. tomorrow before class starts. So we will go over both homework assignments tomorrow morning. Of course, we'll discuss those.
And Julie, we just get those to you by emailing you.
Say it again, Camille, sorry.
Okay, sorry, we email you. That's how we get the homework to you.
Yep,
Your
either
email,
email or
okay.
text, whichever one's easier for you.
Okay.
Yep. And I'm trying to respond and let you know that I received. So one of you, I know I got just a little bit ago, so you're good. I'll respond to that in a minute. Then the rest of you have in tomorrow. So we'll look at both of those assignments tomorrow. We have to take a quick lunch. I mean, I can't have us here. We won't be till 5 o'clock tomorrow, but we have to take a quick lunch. So we'll do that. We'll do a review. We'll take a test and you guys can check off 301. How's that sound? Is that a good plan for tomorrow? All right. 9 a.m. sharp. We're going to start tomorrow morning. I look forward to the rest of your homework assignments. You guys have a good night. Don't party too hard tonight. You got to take a test tomorrow. And we'll see you guys tomorrow. Party, right? Too old.